Simmons.
Good afternoon, ma'am. This is Merle with the Joint Committee on Legislative Claims Against the State. I'm trying to reach an inmate, Billy Brown. Is he available?
Yes, he is. He's right here. One moment.
Good morning.
Good morning, Mr. Brown. This is Susan Humphreys, and I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7335 for property loss in the amount of $1,746.15. You're on the speakerphone right now with the committee here in the State House. The committee's been provided with all of the documentation for your claim for our review. And I'd like to give you a chance to tell the committee anything else that you would like us to know. And then after that, we'll hear from the Department of Corrections. And then when all of that is completed, the committee will take some time to consider your claim, and our written decision will be provided to you within 21 days. Does that make sense to you?
Yes, it does.
Okay, very good. So go ahead and tell us what you would like us to know in support of your claim.
Okay, I was over at the Larned State Hospital, and when they transferred me to KDOC, the Larned State Hospital packed up all my stuff and sent it to Lansing, and then from Lansing they sent it down to here where I'm currently at, and then they sent me a notice that they was going to destroy all my property, but I am to return back to Larned State Hospital, and they were aware prior to when I came into KDOC that I was returning back to the state hospital, and for that reason, I'm supposed to keep my property with me, is what the state hospital said. And when I got here, they did give me some of my property, and I need to adjust that because they just gave me some new property on 12/5, and I need the claim to be now $1,622.45. Deducted some of the property that they gave. So the actual new claim amount would be that amount I just gave you, the $1,622.45.
Okay, thank you. Okay, was that it for now? Okay.
Yes.
All right, we're now going to hear from Ty Bushbaum from the Department of Corrections. Welcome to committee. Good morning. Let us know what your response.
Morning, Madam Chair, and thank you. Mr. Brown requests $1,622.45 for property loss. He states that several of his property items were not returned to him after transferring from Larned State Hospital to Larned State Correctional Facility. On July 6, 2021, Mr. Brown was transferred from Larned State Hospital to KDOC custody after being found guilty of conspiring to commit battery of a correctional officer. At the time of his transfer, he had 178 items purchased at the hospital, all of which are stated in his present claim. Mr. Brown was sent to El Dorado Correctional Facility for in-processing. He was then transferred to Lansing Correctional Facility and finally to Larned State Correctional Facility, where he filed his first formal complaint regarding the property. On April 18, 2023, Mr. Brown submitted a grievance to Larned State Correctional Facility staff regarding a wristwatch and several food items he believed should have been given to him upon his transfer from the hospital. Mr. Brown's grievance was investigated and denied because he was not allowed to have the items under IMPP 12120 and IMPP 110101. The items were not purchased from facility-approved vendors, and some items were non-compliant with department property rules. He appealed this decision directly to the Secretary of Corrections on May 4, 2023, as an emergency grievance pursuant to KAR 4415-106. The grievance was denied due to not meeting the regulation's definition of an emergency. In his present claim, Mr. Brown requests 178 items which, at the time his claim was filed, were being held by Larned State Correctional Facility's Admissions and Discharge Office. The items include food products, healthcare items, electronics, and clothing. They are listed in the inventory sheet provided. Mr. Brown was notified multiple times by Lansing and Larned Correctional Facility staff that the items must be disposed of according to IMPP 12120. He had the option to sell, donate, ship, or have the property retrieved by friends or family. For over a year, he did not act. He responded to staff notices by continually stating that his family was working to come and collect the items, though they never did. In an effort to resolve the issue, Mr. Brown's unwilling. To resolve the issue, after Mr. Brown's unwillingness to cooperate, the facility conducted another inventory of his property on October 6, 2023. An inspection was done of the items that are ordinarily allowed in general population. 10 of the items were determined safe and were given to the claimant, as stated in the attached property claims receipt. Many of the food items were past their expiration date and were discarded for health reasons. Mr. Brown has been notified that he may submit a property claim at the facility level for these items, and the facility will consider reimbursement. Therefore, an administrative remedy still is available. The remaining items are unable to be cleared or violated department policy and property rules. This included his 32-inch TV, which size is prohibited under IMPP 12120. Mr. Brown is a ward of the Department of Aging and Disability Services and a civil commit of the Sexual Predator Treatment Program. Upon completion of his sentence, he is to return to the Larned State Hospital. As a result, all remaining property items were returned to the hospital where they are being held upon his return. KR 44-16-105 and IMPP 01-118 state that residents own property at their own risk, and claims shall not be paid unless loss or damage directly resulted from staff negligence. Mr. Brown's property was not lost due to staff negligence, but was properly withheld under department security procedures. Based on the foregoing, the department recommends that the claim be denied.
Okay, thank you. Committee, do you have any questions first for Mr. Bushbaum, and then we'll see if you have any questions for Mr. Brown? Okay, yes, Senator Dietrich.
Thank you, Madam Chair. So there's a lot of information here. Maybe I missed this. Where is the property now? You say there's an administrative remedy still available. So that must mean that the property may still be somewhere.
Senator, the property has been transferred to the hospital, Larned State Hospital, and is currently in their holding.
And if I may, Madam Chair.
Yes.
And so he cannot access that until he's returned to the hospital?
Correct, Senator. There are items in there he's not allowed to have. Either they don't match department policies, or yeah.
Okay. Thank you. I just want
If I could just clarify that a little bit, it seems to me that the food items that were past their expiration date and they were discarded, but he could get a remedy for those, and the facility will consider reimbursement for the food items that were past their expiration date. Is that right? I'm
Yes.
looking at that paragraph.
Yes, Madam Chair.
Okay, and then the next paragraph says that if he's returned to Larned State Hospital, all remaining property items, they're returned to the hospital and they're being held for his return. So do you know which? I know some of them, this 32-inch TV is too big. Some of them don't fit in the regulations, but you have any idea what property is still being held for him that he will get when he returns?
Madam Chair, I was unable to actually get an inventory sheet for what was sent. However, the inventory sheets that are attached, there are two of them. One of them itemizes the original inventory of the property, all 178 items.
Mm-hmm.
And the attached sheet of the property that he received 10 items total of that 178. And it is included as attachment, I believe it's attachment A. Yes, my apologies, it's attachment C. He received black sandals, his radio, headphones, his watch, battery charger, surge protector, comb, boxers, socks, and a calculator. Those items were deemed to be safe even though they weren't purchased from a facility canteen, and they were to return to him. All of the other remaining items, aside from all of the food items on the original inventory sheet, were then sent to the hospital. So that includes the television set and some clothing and other things like that.
And are you saying when he returns to the hospital, he may be able to access those?
He will be able to access them.
He will be able to access those.
Yes, ma'am.
Okay. Okay, thank you. Any other questions? Yes, Representative Mon.
Thank you, Madam Chair. So when is he going back to the hospital? And is that a guaranteed thing that he will actually go back to the hospital, or what?
Yes, Representative, it is a guaranteed thing. He is a warden of the state, and he must return to that training until the Department of Aging and forget their name, until the department releases him from the sexual predator treatment program, and he will have access to those items upon his return.
So he serves out his sentence in DOC and then goes to the hospital after that. Is that
Yes, Representative.
so? Um, his sentence. How long is that going to be?
I believe his sentence terminates in 2025, but I'm not entirely certain about that.
Right. So he spends the next couple of years in DOC and then goes to. And I get it, but he then goes back to the hospital at that point. But in the meantime, he's denied his access to his property.
Yes, Representative. The property should not have followed him from the hospital to KDOC facilities. That is not something that is done. This was a mistake, and Lansing Correctional Facility, upon his transfer there, they accepted the property and held it in storage until it could be sorted out to be sent back.
All right. Thank you, sir. Thank you, Madam Chair.
Thank you. Does anyone have any questions for Mr. Brown in the committee? Mr. Brown, did you hear that discussion?
Yes, I did. And nobody's gave me any written notification that they sent those items back. And nobody from KDOC has came and spoke to me about the items, wanting to throw the items away, or what they actually returned back to the Larner State Hospital. Nobody's came and told me anything that they did return the DV, and threw away the food. All they did is brought me the stuff that was on that list, like the clock radio, the JVC headphones, and they did that on 12/5 of 2023. So it hasn't been that long ago. But as far as the other items saying they sent the TV back over to the Larned State Hospital, that no one's came to me. Nobody from KDOC has sat down and said, okay, back at the hospital.
Okay. Mr. Bushman, did you want to say, you act like you wanted to say something.
Thank you, Madam Chair. Just briefly, COI Cook is the one that gave the resident the property on 12/5, the 10 items that he did receive from the initial inventory. He notified the claimant that, in fact, his food items were destroyed and that he was able to file a facility property claim for those consumable items.
Okay, thank you, Mr. Bushman. Okay, so Mr. Brown, I think you heard that, and so it seems like you might be able to have a different, an alternative way to receive back the reimbursement for the food items. Our committee will discuss your case, and we will provide you with a written notice within 21 days. Does that make sense?
Okay.
Mm-hmm.
Yes, it does.
Okay, very good. Thank you.
Thank you.
Okay, bye-bye.
Bye.
Bye. Representative Rajas.
Okay, I guess I have a question. This could be on hold for a couple of years, really, because there's really nothing for us to act on until he goes back to the state hospital and he can see what he had. Because right now there's really nothing for us to. There's nothing for us to act on. We can't. So I guess
Are we just gonna, we could discuss this one now and go ahead and make a decision on it. You want to make a motion?
well, we haven't done that one.
You go ahead and ask your question. Let's finish your questions.
I guess it's more of a procedure question because this seems to be very open ended.
Mhm.
If I guess it seemed to me
We do need to address this claim. We have to do something with.
But if we do as we've done in the past without prejudice, I'm not an attorney.
Mhm.
Without prejudice, I mean, what's the point? Because it's still open ended. This to me, this isn't a sealed deal to either up or down. This is still open because with him not having access to it, we're claiming something that I don't think, either side knows that there's a actual claim to this. What I've heard from both DOC and the claimant is that, DOC says he will have access to whatever's left in 25, 6, whenever he goes back to the facility. So I guess my question is this kind of like hanging, or if we act with prejudice, it still would kind of it'd still be in the queue. Is that right?
What it means is we've dismissed the claim. We're done unless he brings it back up. And when it's without prejudice, he has the opportunity to bring it back up. If we dismiss it completely, then
You would have
it's
to
done. There's we're
Okay.
done with it.
Okay.
And then there's the second part, which is that expired food, which he hasn't exercised all of his remedies yet on that one.
That could be done internally without.
Right. We have to. But as long
It was more of a procedure question because we haven't dealt with something like this to where they're in a different facility kind of from where the action took place.
Yeah.
Okay.
Well, and as long as we're discussing it, I would go ahead and take a motion if we know. Senator Dietrich.
Sure, I'd be happy to make that motion. So pursuant to Rule 3, I move that the committee denies without prejudice claim number 7335.
Second by Representative Vaughn. Any other discussion? Okay, all in favor, say aye. Aye. Opposed?
Aye.
Madam Chair, I
Yes.
just wanted to clarify
Yes,
really quick
thank you.
with
Good.
the chair, with the vice chair referenced Rule 3. I think you meant to reference Rule 2. Rule 2 is the one that says has not exhausted all
Thank
other
you so
remedies.
much. Thank you. I read my own writing.
Okay, thank you. So that one is denied without prejudice. So we're done with that one. I do want to go back to Representative Rogers in just 1 second. Welcome, Senator Haley. Glad that you're here. Okay, so Merle, would you clarify if we had dismissed with prejudice, just dismiss, he could not bring it back, is what I understand. Is that to explain a little bit about that? So maybe that would help.
Yes, Madam Chair, that is the primary difference. When this committee denies a claim, that claim is resolved, and generally that the committee will never hear. The claimant is not allowed to refile. There is some conditions in which, with a vote of 4 in rare circumstances, they can reconsider, but generally deny means you'll never hear from them again. Dismiss without prejudice or deny without prejudice means that claim is dismissed, but the individual can file again, but they would need to submit a new claim and file that, and it would be considered as a new claim.
It's like you have an appeal or you don't have an appeal. Okay, thank you. Thanks, everybody. All right, we are going to move on to the next claim, number 7356.
We're dialing them now, ma'am.
Thank you.
Morning. My name is Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. I'm trying to reach Scott Anderson. Is he available?
Lawrence State Correction Facility. I want to make sure you can hear me. Hello?
Yes, sir. We can hear you. We are
Hello?
trying to reach a
Okay. Scott Anderson? Yep, he's right here. Hello.
Okay, Mr. Anderson, are you there?
Yes, I am.
Okay, thank you. This is Susan Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7356 for personal injury in the amount of $2,500,000. You are on the speakerphone with the committee in the State House right now. We've been provided all of your documentation, including a description of your personal injury. I'm going to give you the chance to tell the committee anything else that you would like us to know about the situation. When you're finished, I'm going to ask the attorney for the Department of Corrections for their side regarding this claim. And then when that's completed, the committee will take some time to consider the claim. And within 21 days, we will get back to you in writing. Does that make sense to you?
Yep.
All right, hang on just 1 second if you don't mind. Okay, I'm sorry for that delay. Okay, so Mr. Anderson, why don't you tell us about your claim?
All right. So I was transferred from Winfield to El Dorado on 4/15/2020, and I never lost my custody. I was still minimum custody. Within the time frame of 4/15/2020 to 5/17/2022, I have requested multiple times from Unit Team Johnson to be transferred properly to a correct housing, minimum custody housing unit. In that time, I worked M-marked minimum wage, and then I was sent to D2 unit in March. And then during March, there was an inmate who was harassing, retaliating me, and trying to get stuff out of me. And on 4/19/2022, it's called block cell outage, like you come out and block. And it was my turn to come out. His cell was still locked down, and for some reason, I just felt like it was a weird situation that day, and I went ahead and came out, stood by my cell door, and all of a sudden, the CO had popped his door. He went to the ice machine, grabbed an ice scoop, went upstairs, handed it to somebody, came downstairs and told me to go to my cell, and I kept telling him no, no, no. And then he turned away and came back, pushed me in. Once he pushed me into the cell, he hit me, kicked me, threw my head against the wall a couple times, turned the light out, and he had kicked me in my private part where I had to get a circumcision done. Then I started filing paperwork for the grievances and stuff and personal injury claim. And once I started that, I was, in my eyes, I was retaliated and sent to Norton, where they prolonged my surgery, and the surgery didn't happen until 12/14 of 2022. And the violations that I feel that the Unit Team Johnson didn't fulfill was KSA 755210. And the Warden and Secretary of Corrections, I feel like they violated that KSA. Also KSA 755251 and KSA 755252.
Okay, thank you. Is that it, Mr. Anderson?
Yes.
Okay, thank you.
Yep.
Okay, we're going to hear now from Mr. Bushbaum from the Department of Corrections.
Thank you, Madam Chair. Mr. Anderson requests $2,500,000 for personal injury. He claims PTSD and injury to his head and genitals resulting from an attack by another resident. Mr. Anderson submitted a personal injury claim on July 6, 2022, in which he sought $80,000 for PTSD and distress compensation. He states that 3 months prior, on April 19, 2022, he was attacked by a fellow resident and sustained head, genital, and emotional injuries. He also claims that medical staff did not provide him with a CT or MRI scan upon request. The claim was denied in July of 2022, due to an investigation finding that the requested sum was beyond the facility's ability to pay, and that medical staff made the determination that a CT or MRI scan was not necessary. In his present claim, Mr. Anderson requests $2,500,000 for the same injuries he alleges in his facility claim. KAR 44-16-104A and IMPP 01-118 state that residents must submit claims for personal injury to the facility and Secretary of Corrections within 10 calendar days of the claimed personal injury. Mr. Anderson's injuries occurred on April 19th, 2022, and the claim was not filed until 2 months later on July 6, 2022. The claimant is not eligible for compensation. Additionally, on October 15th, 2023, Mr. Anderson filed a civil rights complaint with the United States District Court for the District of Kansas. The complaint seeks $20 million in compensation for personal injury. It alleges the same facts, injuries, and evidence that Mr. Anderson now presents before the Joint Committee. Pursuant to Rule 2, a claimant should first exhaust any judicial remedies that may be available. The Department recommends that the present claim be dismissed without prejudice so that Mr. Anderson may first pursue his judicial remedies. Thank you.
Thank you. Committee, do you have any questions for Mr. Bushman? Yeah, so Representative Mond's going to go ahead and explain something to us now.
Mr. Anderson, are you still there?
Yeah.
So I'm Carl Mon. I think that I may have represented you on appeal at some point. Do you think that that's correct?
No.
Okay. In that case, I'll withdraw my reservations. I can't. The name is familiar to me, but Scott Anderson is obviously not necessarily a unique name. So I may have represented a different Scott Anderson, but with Mr. Anderson's indication that I have not represented him, I'll withdraw my reservations.
Okay, thank you, Representative Mon. So Representative Mon was going to, I don't know if the proper word is recuse himself, that's something like that. In this case, because he may have had some previous experience with Mr. Anderson, but it seems like that's not the case. So, but in any situation where any of us have had a representative or represented someone that's for hearing their claim, that would be the proper thing to do. So thank you for being careful about that. Representative Mon. Okay, any other questions for the Department of Corrections first? Okay, does anyone have any questions for Mr. Anderson? Mr. Anderson, I just want to confirm that you do have an ongoing civil case. Is that correct?
Correct.
Okay, thank you. All right, so I don't know if you heard the recommendation of the agency. This committee is a committee kind of last resort. You do have something ongoing. So the committee will discuss this. We will come to a decision and we'll provide you within 21 days of written a notice of our decision. Does that make sense?
All righty. Yep.
Okay, thank you. All righty. Bye-bye.
Yeah. Bye.
Committee, I think we'll just take care of this one right now too, as long as we're right on top of it. Is there a motion?
Okay. Thank you, Madam Chair. I would move pursuant to Rule 2 that the committee dismiss this complaint without prejudice.
Seconded by Representative Rajas. You heard the motion. Is there any discussion? All those in favor say aye. Aye. Opposed? Okay, then that claim number 7356 will be dismissed without prejudice. All right, we will move on to claim number 7357. Actually, in that case, the claimant accepted $81 for settlement of that facility claim. It was signed on December 5th. I think that's in our documentation. Is that correct?
That is correct, ma'am. And I will give you a page number here.
Okay.
If you look on page 146 of your PDF packet, you will see a document, a settlement agreement generated by the agency, and that is signed by Christopher Kern on 12/5/2023. A settlement in the amount of $80.87.
Thank you. And Merle, tell us what is the proper way to handle this claim?
Yes, ma'am. So the settlement means that the facility claim has been settled. So the legislative claim for this committee would still be outstanding. So the committee could either take the action. The committee could either dismiss without prejudice, so that individual could come back at a later point, or could deny. Traditionally, in the past, I think we have dismissed without prejudice when it became to these settlements, but the provisor might have an opinion.
Okay. All right, let's go ahead and take care of this one too. Claim number 7357 that has been settled for just $8.86 less than what they claimed. Do we have a motion?
Thank you, Madam Chair. I'd be happy to make that motion. I would move that the committee dismiss claim number 7357 without, or dismiss it without prejudice at this point.
Maybe, excuse me, it may be better just dismiss the claim because it's been settled and you don't want the thing to come back. So, right. So I think dismissed because the motion should be dismissed because the claim has been settled.
Like to
restate that? Thank you. I will move that claim number 7357 be dismissed because the claim's been settled.
Second by Representative Vaughn. Any more discussion? All those in favor say aye. Opposed? No. Okay, then we will dismiss claim 7357. Thank you. And we're moving on to claim number 7358. And we are more or less right on time. So it's good news. We'll go ahead and make that phone call.
Good morning. My name is Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Mr. Timothy Frobrish. Is he available?
Yes, he is. 1 second.
Okay, hi, Mr. Frobish, are you there?
Hello?
Hello, Mr. Frobish, good morning. This is Susan Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7358, property loss in the amount of $450. You're on the speakerphone with the committee here in the State House. The committee has been provided with all of your documentation, and I'm going to give you the chance to tell the committee anything else you'd like us to know about the claim. After that, the attorney for the Department of Corrections will let us know their response. And then when all of that's over, the committee will take some time to consider the claim, and we will provide you with our written decision within 21 days. Does that make sense to you?
Yes, ma'am.
Okay, thank you. So why don't you go ahead and tell us what you'd like us to know in support of your claim?
This issue's been going on for several years now, unfortunately. I've even, I mean, you guys have all my paperwork there. I've took it to even to court, but they said that was the wrong jurisdiction. And I think I talked to their attorney, Mr. John Graves, and he asked me to send him a letter to see if we can't get it resolved, but I was eventually told by the A&D officer that unless I have a written thing from the state saying that he has to give me my property back, until then he wasn't going to. But everything else is, I think, is all in writing. Hopefully I sent it all. I know it was quite a bit, so.
No, we do have, I think, the forms and everything that you filled out. We're looking over those now too, but go ahead.
But I don't know if I sent a copy of the letter I sent to Mr. John Graves. I don't know if that's who the attorney is today. But other than what I have written there, the only other thing is, I wouldn't be, continuously trying to claim what my property is if it wasn't mine. And you guys can understand 2 years of frustration, on both sides, not just me. I'm sure they're frustrated with me, nagging them, which, is understandable. But just hoping that, I don't know if I've written it in there or not, but I wanted to point out I don't want money reimbursement. They have it up, they have the tote of beads or property up in A&D, and I would just like to have that back. I don't want, rather not have money. I'd just rather have my property.
Okay, thank you. Thank you. All right, we'll hear
Thank
from
you.
the department now. Mr. Bushbaum.
Thank you, Madam Chair. Mr. Frobish claims that some of his craft items, in this case numerous beads, were missing upon his return from restrictive housing. On September 1st, 2021, Mr. Frobish was placed in restrictive housing after receiving 2 disciplinary reports for theft and possessing sexually explicit material. 2 officers removed Mr. Frobish's property from his cell and inventoried each item. Upon his release from restrictive housing on November 16th, 2021, Mr. Frobish submitted a facility property claim in which he sought $450 for a container of craft items that he alleges was missing. He claimed that after talking with some people, he discovered that an officer left his cell door open, allowing another resident to steal from him. On December 5th, 2021, the claim was denied because Mr. Frobish, in front of CSI 2 Perez, reviewed the property that was returned and signed the inventory sheets detailing the property. The facility found no evidence that his cell door was left open, and none of the more accessible or valuable items from Mr. Frobish's inventory sheets are claimed to be stolen. In his present claim, Mr. Frobish asserts the same facts and requests the same compensation as his facility claim. In his attached small claims petition, he states that he discovered the items were being held in the facility's property storage area, otherwise known as the Admissions and Discharge Office. In response, the facility conducted a thorough search for any tote or loose craft items in the A&D office. The search was done by the corrections supervisor for the office. No tote or craft items were found that matched the receipts provided by Mr. Frobish. His claim that his property was being held in that office was found to be unsubstantiated. In his facility claim, he states that he sent an unspecified portion of the property home. It is impossible to determine how much of the claimed property this may include. In this regard, the craft beads are similar to consumable items. They can be difficult to track or affirmatively ID over time due to their sheer number and size. The attached inventory sheets show the craft items in question and Mr. Frobish's receipt of them. IMPP 12120 states that residents must sign all completed inventory forms, which attest their accuracy, and any discrepancies are to be noted on the inventory sheet. Mr. Frobish reviewed and signed every page of the inventory and made no notations in reference to the items he claims. He has filed multiple property claims and is aware of the process. KAR 44-16105 and IMPP 01-118 state that residents own property at their own risk and claims shall not be paid unless loss or damage directly resulted from staff negligence. The claim fails to show that Mr. Frobish's alleged loss of property was the direct result of staff negligence. Based on the foregoing, the department recommends that the claim be denied. Thank you.
Thank you. Does the committee have any questions for Mr. Bushbaum? Any questions for Mr. Frobish? Anyone on the committee? Okay, Mr. Frobish, we will discuss your case and we will let you know within 21 days with a written notice. Okay?
Okay.
Yep, if you have something else you want to say, go ahead.
Yes, please. As to the, I'm sorry, I didn't get the attorney's name, but he said that that the tote was not found in property. Almost every CO that works here knows that it's down there and they've seen it. So I don't understand why that was said, but I'm sure that was the A&D officer's report. As to the inventory listed, once I found out that the property was gone, I talked to Officer Chandler, who gave the property back, and he said, "Oh, I will get it resolved." And that's when it was. I left it because I trusted the officer to keep his word. As to anything else, I mean, I know it's down there. So
did I understand that you have the tote with you now, or all the craft items are in the tote and that's also missing?
Yes, all the craft items are in the tote,
Okay.
And said tote, I still have the dividers in my room right now that goes with that, and I've tried to bring that up to him, but, you know, the A&D officer would not allow me to bring all my evidence down to him. He just
Okay.
kept putting me off.
Okay. Okay, thank you. Committee, any more questions? Okay, thank you, Mr. Frobish. We will discuss it and we'll let you know our decision.
Thank you very much.
Okay, thank you. Bye-bye.
Bye.
Okay, committee, we're going to move on and do a few more and then we'll stop and kind of do all of them at once with motions and decisions. So we'll move on to claim number 7355. Okay, very good. Dialing now.
Morning, my name is Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach James Strader. Is he available?
Hold just one moment and I'll have him right here, okay?
Thank you.
Mr. Strader? Okay, I got him on phone for you. Hello?
Hello, Mr. Strader. Good morning.
Hi.
Yeah. Hi, this is Representative Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7355, personal injury in the amount of $10 million. You're on the speakerphone right now with the committee. We're in the State House. The committee has been provided with all of your documentation of your claim. And I'm going to give you a chance to tell us about anything else you'd like us to know. Then when you're finished, I'm going to ask the attorney from the Department of Corrections to give us their response. And then when all that is complete, the committee will take some time to consider your claim, and our written decision will be provided to you within 21 days. Does that make sense to you?
Yes.
Okay, great.
I
So
got one more question too. I do got one more question.
Sure. Go ahead.
I also got on there wrongful conviction, not just personal injury.
Okay. The one that we're hearing right now is the personal injury. Hang on just one second. We're going to hear from our...
I'm pretty sure it was together.
Madam Chair, this is Merle Meadle with legislative staff. If you look at that individual's claim, he's listed a dollar amount for personal injury. He's also listed a variety of other things for which he is seeking satisfaction. This committee just generally considers the monetary issues related to the personal injury. So he is he references requesting a change in sentence and other matters.
Okay, so Mr. Strader, this committee is dealing with the money issue, and then the other issues that have to do with some other sort of legal remedies. We don't have any jurisdiction over that. So we'll be speaking of the personal injury case. Okay, why don't you tell us?
I was just trying to figure out on because the prosecutor became the judge and he's holding up everything.
Well,
so I'm trying to figure out what.
Yeah, that's sort of out of our purview. But why don't you go ahead and tell us about the personal injury claim?
Okay. Officers, while I was in cuffs, had me, took me in and they dropped me and they broke my neck and hid me in seg. They also stuck something in my anal and they tried to say I had dope in my rear end and I did not. And they took me from the infirmary against a doctor's medical order. She had me in there for suspected head injury because the day before the officers had jumped on me and one of them used handcuffs as brass knuckles. And they came in against doctor's orders, pulled me, took me down to seg, and that's when my neck got broken. They hit me down there. They caused amnesia, a brain injury, and I had to go to a neurosurgeon named Thomas from Pong. I got a surgery that I wasn't even supposed to get. They were going to do a different surgery that we agreed on, and it was so bad he had to do something different. I now have tingling down my arms all the time. I'm pain a lot. The brain injury's still not there, and I still have some memory loss. That's about how I can put it. They literally did frivolous DRs. I mean, after they found out about this claim, I wound up losing my job. Was forced to move out of the unit I was in, which was an honor unit. There's been all kinds of just torts that's been going on. They changed my medical records to make it look like I had schizophrenia. I've never had a mental problem in my life, except for with this brain injury.
Okay, thank you. We're going to hear now from the attorney from the Department of Corrections,
Okay.
Mr. Bushbaum, and then we'll come back to you if we have any questions. Okay, Mr.
Okay.
Bushbaum.
Thank you, Madam Chair. Mr. Strader requests $10 million for personal injury and property loss. He claims several physical and psychological injuries, as well as stolen medical records. It was unclear what exactly he was claiming in his legislative claim. And so for a review of his facility claims, I found that he filed 3 personal injury claims while in KDOC custody. None of them mention a broken neck. However, if the committee wishes, I will go through those 3 personal injury claims at their request. However, I feel it with time probably to skip ahead to his present claim. In his present claim, Mr. Strader mentions brain injury, head trauma, and neck trauma as a result of surgery on June 21st, 2023. He also claims unspecified long-term life-threatening injuries along with mental and emotional anguish. The department submits that this claim represents a situation where application of Rule 2 would be equitable and reasonable. Mr. Strader has filed no personal injury claim so far in 2023. As the surgery occurred in June that he alleges in his claim, he is not in compliance with KAR 4416-104A and IMPP 01118, which require residents to submit claims for personal injury to the facility and Secretary of Corrections within 10 calendar days of the claimed injury. Additionally, Mr. Strader has not exhausted his judicial remedies. The claim represents complex issues of medical expertise, the facts are in dispute, and the department's liability is not clear, as well as the amount in question is not so nominal as to make the pursuit of judicial remedies unreasonable. The legislative claims process is intended as a place of last resort where there is no other way of appropriating money to pay a claim against the state, and that is clearly not the status of Mr. Strader's present claim. Based on the foregoing, the department recommends that the claim be denied.
Okay, thank you. Are there any questions for Mr. Bushbaum? I do have a question. Just hang on, Mr. Strader, hang on just one second. Let me ask
Okay.
the attorney question. So I thought I heard you say that Rule 2 would be equitable and reasonable in this case, but then at the end you just said your recommendation is deny.
Yes, Madam Chair. Dismiss without prejudice. I guess there's a difference there. I apologize.
Okay, I just wanted to clarify that. Yes, Mike. Our revisor has clarification or something for us.
Actually, I have a question. Does the Department of Corrections know if this inmate actually had a broken neck?
There has been no evidence in his medical records to substantiate that, and there has been no claim made to the facility in which he resides that such an injury has been sustained.
Okay, committee, do you have any other questions? Yep, I'm coming. Hang on one second. First, committee, do you have any questions for Mr. Bushbaum from the department? Okay, now, Mr. Strader, go ahead. Tell us what else you'd like us to know, and then we may have a question for you.
Okay. I did do those remedies, and there was thousands of grievances. I even got in trouble by the federal court for e-file remedies I tried. They violated due process every time I tried to do it. The injury, when it happened, they hit me for 5 years. The doctor from Palm, the neurosurgeon, was really upset when he found out that they took 5 years to get me there, almost 5 years. They hid everything. They hid me from my family. They shut my phones off. They shut my JPay off. They wouldn't allow me to talk to anybody. They cleared my visitation list. They even took my parents off my visitation list so that nobody could get in to see me or talk to me. And some of that is still going on.
Okay. Thank you for that additional information. It's a little bit out of our what
Well,
we can do here today?
what I was getting at is there's federal judges that can testify that those remedies were done. He's mistaken, or somebody's mistaken with him and not told him the truth.
We're looking at the documentation. Mr. Bushman, would you have a response?
Yes, Madam Chair. He may have filed many grievances, of which the grievances that I reviewed over the last 2 years did not mention any neck injuries. However, grievances are not personal injury claims. KR 44-16-104A specifically states that it has to be a personal injury claim filed with the facility. A grievance for the department will not do that.
And that would be a separate action or not allowed?
So considering that the surgery he claims caused the neck injury was over a year ago, he would not be able to file a personal injury claim at this time because KR 44-16-104 says that it has to be filed within 10 days of the injury being sustained.
Okay. Okay, thank you. All right, any other questions, committee? Yes, Representative Mon.
Mr. Strader, this is Representative Mon from 90th District. I just have a question. Do you have a pending civil lawsuit?
Yeah, and they keep hindering it. That's the problem. Every time I try to get into court, they've been sending expired checks. They say that the remedies weren't done. I actually had a state judge out of Leavenworth recuse himself to become a material witness because he even knows that they're lying about the remedies not being done. The personal injury claims were done. There was one done, but see, I didn't know my neck was broke because they were hid me in SEG, and they wouldn't even take me to the doctor. I've got probably 60 staff members that was working for them, and there's some on file at the courthouses because they stole those statements, but they signed statements. They kept telling the nurses that they needed me out there, and the captains were giving orders saying, no, he has to stay down in SEG. They wouldn't allow me to even go to the infirmary. So and it took them 5 years to get me to the surgery. So the surgery just happened in June. So with all the pain that was going on and the stuff with my neck, what they told me was there was spinal cord damage, and if I sneezed, I could have paralyzed myself because of the way everything healed. They literally hid me, and my medical records do show that he is very mistaken on that. Unless they've gone in there and changed my medical records again.
Yep.
But Dr. Frimpong said he will release any medical records you need.
So the question is, do you have a pending lawsuit on file?
Yes, I did.
Okay, thank you. That's okay. Thank
yes,
you.
I do.
Committee, do you have any other questions? Okay, Mr. Strader, we have your documentation. Thank you for answering our questions. We will discuss the matter, and you will hear our response within 21 days, our written response. Okay, that makes sense.
Okay.
You can say one. Yeah, if you have one last comment, please go ahead.
Do you guys need me to have the neurosurgeon release those records to you? Because he'll give you his records instead of KDOC's.
If you have a pending lawsuit, this committee is really a last resort. So it's the question is that would probably need to be settled first, and then the committee will talk about what our decision is. But we're going to take that into consideration, the pending lawsuit. Okay.
I tried other lawsuits. I did refile another one, trying again. And I got an attorney on it, but we're getting nowhere because they keep pulling little stunts like not sending the checks that need for services, all kinds of stuff like that. Yeah. So, I mean, it's their torts that's keeping it out of court to proceed.
Right. In our committee, we just have certain, it's a legislative committee that's set up for a very specific reason. And so, we have to kind of stay within our...
Yeah, I know you do.
Yep. Okay. All right. Thank you, Mr. Strader.
All right. Thank you.
All righty. Bye-bye.
All right. Bye.
Madam Chair, I'll move to dismiss without prejudice, given that he has pending
Okay, we have a motion on the floor, claim number 7355 to dismiss without prejudice. Is there a second? Representative Vaughn seconds. Okay, do we have any discussion? Okay, all those in favor of dismissing without prejudice, say aye. Opposed? Okay, then that one is done. We will dismiss without prejudice claim number 7355. Yeah, we have two others above us. Let me see what time it is. I think we're going to move on and do a couple more and then go back. But I haven't forgotten that we have, actually, we just have one. Yeah. Okay, let's move on and just trying to stay a little bit on task here. Okay, we're dialing for claim number 7359.
Morning, my name's Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Marvin Gay. Gray. Is he available?
Yeah, just a moment. Here you go. Hello?
Yes, hi, Mr. Gray. Is that you? Is this Mr. Gray?
Yes, ma'am.
Okay, great.
Yes,
Mr.
ma'am, it
Gray,
is.
this is Representative Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing
Yes,
your
ma'am.
claim number 7359 in the amount of $145.80 for property loss. You are on the speakerphone
Yes,
right
ma'am.
now with the committee in the State House. In a minute, I'm going to ask you to give us any more information that you'd like us to know. We have all of your documentation here in front of us. And then when you're finished speaking, I'm going to ask the attorney for the Department of Corrections to give us their response. And then when all of that is completed, the committee will take some time to consider your claim, and our written decision will be delivered to you within 21 days. Does that make sense to you?
Yes, ma'am.
Okay, great.
Yes,
So
ma'am.
why don't you let us know tell us what you'd like us to know about your property loss claim.
Okay. Well, it was initially approved publication until they made amendments or made changes to it to where the pictures that I had received through mail were no longer approved. And instead of based on the rule book where it says inmates shall have the option of having censored publications in their entirety either mailed out of a facility at their own expense or discarded, it was just flat out destroyed instead of giving me the option to do with it what I needed to or wanted to, give me the option. And it's also stated in IMPP 12-134A that in the event publications was originally approved but later disapproved, the Secretary's designee is to instruct the designated facility staff to change the publication for censorship, list the show publications that are disapproved, and that it's supposed to give the residents input their own expense but not receive disciplinary actions based on the possession of the censorship. They didn't follow that. They just flat out destroyed the property.
Okay, thank you. We're going to hear now from the attorney with the Department of Corrections. We'll come back to you if we have any questions. Okay?
Okay.
Okay. All right. So, Mr. Bushbaum, go ahead.
Thank you, Madam Chair. Mr. Gray requests $145.80 for property loss. He claims 118 lingerie and swimsuit model photos were removed from his cell and destroyed by Hutchinson Correctional Facility staff. On January 1st, 2023, Mr. Gray received 3 disciplinary reports for disrespecting an officer, threatening or intimidating any person, and disruptive behavior. He was removed to restrictive housing, and his cell was packed out and inventoried. On January 31st, 2023, he submitted a property loss claim in which he sought $145.80 for the photos, which he claims were in a photo album. He states that the photo album was stripped of all photos and returned to him. The claim was denied because the investigator did not find the pictures or photo album in the January 1st, 2023 inventory sheets, which Mr. Gray signed upon the return of his items. In the present claim, Mr. Gray requests the same compensation and alleges the same facts as in his facility claim. The inventory sheet that was done as his property was being packed out on January 1st, 2023, does not list a photo album or photographs. IMPP 12120 states that residents must sign all completed inventory forms, which attest their accuracy, and any discrepancies are to be noted on the inventory sheet. Mr. Frobish reviewed and signed every page of the inventory and made no notations in reference to the photographs. However, in the event Mr. Gray's version of events is true, he did have over 100 lingerie and swimsuit photographs, he would be in violation of facility and departmental policy regardless of when he acquired them. IMPP 12120 states, any property which, in the original state or through alterations or additions, displays graphics, depicts or mentions the glorification of drugs, alcohol, or sexually explicit materials is prohibited. As to Mr. Gray's defense that the facility's censorship policy instructs that if photos are allowed and then not allowed, the inmate is to be given the option to send them home without disciplinary action. This is incorrect. The policy which he is referring to, KR 44-12-601G4 and IMPP 12-134, pertain to publications such as books, magazines, graphic novels, etc., not photographs collected in an album. That is not a publication. Sexually explicit photographs are specifically defined under IMPP 12-134, Attachment A, and regulated under IMPP 12-120. No provision allows for such photographs to be sent home. Both of those are attached. Mr. Gray states he received the pictures from Surrogate Sisters, a company he claims operates through the commissary. Surrogate Sisters is not an approved facility vendor, and any purchases made from them were not facilitated by the commissary. He also states that he has purchased these photographs over several years with stamps. Surrogate Sisters apparently allows residents from across the country to circumvent traditional payment methods by sending unused stamps for explicit photographs. This avoids creating a central inmate banking charge to his account, and therefore no record of purchase exists beyond a receipt the company may have sent him. Since Mr. Gray has not provided any receipts of purchase from the company, something which only he can provide, the sum he requests is unsupported. KAR 44-16-105 and IMPP 01-118 state that residents own property at their own risk, and claims shall not be paid unless loss or damage directly resulted from staff negligence. The claim fails to show that Mr. Gray's alleged loss of property was the direct result of staff negligence. Based on the foregoing, the department recommends that the claim be denied. Thank you.
Thank you. Committee, do you have any questions for Mr. Bushbaum? I have a question just about the policy about publications. Does it mention specifically photographs in a photo album?
It does not. The two policies that are in question here are from IMPP 12-134, which deals specifically with photographs, and the other regulation is a KR, which deals with publications, specifically books. It doesn't mention photographs.
And was Surrogate Sisters an approved vendor before the new rule took place?
So that's a little difficult. The department allows for UTMs to kind of screen through attempted purchases. And so at these times, the UTM may have signed off on them, not fully aware of what they were. The Surrogate Sisters offers a lot of different flyers and pictures that are not sexually explicit in nature. However, the ones that he purchased specifically were. So it appears that they may have gotten around that.
And how do you, if there's not an inventory, how do you know the ones that he purchased were sexually explicit?
He states so in his legislative.
Because of what he stated?
Yes.
Okay, thank you. Okay, any other questions? Senator Haley?
Thank you, Madam Chair. Just to follow up, so Surrogate Sisters was an approved, to the chair's question, during the time that this occurred, they were an approved vendor. It's just their content had not been approved by the department.
In a way, Senator, yes. The facility itself didn't sanction this company. The UTM at the time that approved the purchase apparently did think it was a proper vendor. But even so, he's still not allowed to have the items. And he is well aware of the sexual policy for these photographs.
So is there a list, Madam Chair, sir, is there a list of approved vendors that is traditionally reviewed and gone over, and perhaps what their content is? Does the department maintain a list of those vendors?
So facilities have attempted to do so in the past. However, what we've discovered is that companies become aware of departmental regulations and they will tear down their company, liquidate it, and then create a new one. It takes less than a day to do so, and it's under a different name, and we would be none the wiser, and so the practice continues. So banning lists are ineffective, and vendors that the facility chooses one day to be good and equitable, the next day could very well be a shadow company. So it's very difficult for the department to say yes or no to a specific vendor. So we try to handle it case by case, if that makes sense.
Thank you. Any other questions? Senator Dietrich.
Thank you, Madam Chair. So regardless, though, of whether this is an approved vendor or not, there was no evidence of anything being removed. You didn't find a photo album. You didn't find any pictures. Is that correct? If
Correct,
I'm reading
Senator.
that correctly.
Yes, Senator.
Okay, thank you.
Okay, any other? Yes, Representative Mon.
So, as the chair knows, I've done a large amount of appellate work for folks in DOC. I don't have a question for council, but I do have a question just to for Mr. Gray, just to make sure that we're all above board. Marvin Gray, my name is Carl Maughan, Maughan. Have I represented you in the past? I think that I may have represented you on an appeal at some point, and I just wanted to get your confirmation that whether or not that's true or not.
No, it's not. You haven't.
Okay. All right. Thank you. There is one more on the list, Mr. Jones, the next one that I think I may have as well. So I'll have the same question.
Okay. All right. Very good. Okay. Thank you. Any other questions, committee, for either party? Okay. Then, Mr. Gray, the committee will take some time and discuss your case, and we will let you know our decision within 21 days by written notification. Does that make sense to you?
Yes, ma'am. May I draw attention to one more thing, though, please?
One more thing.
Yeah, there's a what they call a shakedown sheet that's with my things that shows the existence of those fixtures and the fact that they were destroyed. It's a copy of it.
Okay, we'll take a look. We have your documentation, so we'll take a look at that. Okay?
Okay.
All right. Thank you. Thank you, Mr. Gray. Bye-bye. Mr. Bushbaum, do you want to mention that shakedown sheet? I mean, because it's part of our discussion.
Yeah.
This issue.
I do not see a shakedown sheet involved. What I do see is the UTM's, Mr. Hackney was the UTM, who responded to the property claim that he filed. And no existence of photographs were found. He also included a flyer, but there's nothing in his legislative claim that is a shakedown sheet.
Okay, thank you. So we don't have anything in our information either. Okay.
Not that I see, Madam Chair.
Okay, thank you. Okay, all right, we'll discuss that one in a few minutes. I'm going to go ahead and do a couple more. So claim number 7362 with Mr. Jones for property loss. Let's go ahead and make that call.
Good morning. My name is Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Jason Jones. Is he available?
Yes, he's here.
Thank you. Mr. Jones, let me know when you're on the phone. You there?
I'm on, ma'am.
Okay, you're on. Great, thank you. Good morning. Mr. Jones, this is Susan Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7362, property loss in the amount of $109.83. And you're on the speakerphone with the committee here in the State House. The committee has been provided with all of your documentation and including a description of your loss. I'm going to give you the chance in just a minute to tell the committee anything else you'd like us to know. And then after that, I'm going to ask the attorney for the Department of Corrections to let us know their response. And then when all of that is completed, the committee will take some time to discuss your case, and we will come to a decision, and we'll let you know within 21 days, but with a written decision. Does all of that make sense to you?
Yes, ma'am.
Okay, great. So why don't you go ahead and tell us what you'd like us to know in support of your claim?
Okay, on January 30th of 2023, I attended day room. When I left my cell was secured by the officers in the officer station. They locked my room. I went and I used the phone, and I was on the phone for the whole period of my day room time. The officers called 10 minutes to door run. When I went to my room, my whole desk was in disarray, and I had noticed that my radio had been stolen or taken off my desk. I went and reported that to the officer on duty, and she said to return to my cell and lock down, and that she would handle everything once she got the cell house secured. Well, nothing happened that night. She came back by. She said she was going to review the camera, but she never did. The next morning, as soon as my unit team Reynolds, he arrived at work, and I let him know what was going on and that I needed to file a property claim. He said he was going to go review the cameras and find out what was going on with the situation. When he returned from reviewing the cameras, he started immediately shaking inmates down. He went to 3 or 5 different cells looking for my radio. Something that he seen on the video led him to that action. He wrote 3 people theft on my radio, and those inmates pled guilty to the theft of my radio. Now, once I was aware of who stole my radio, I asked them for it back because Reynolds didn't find it. Then the inmate said that I was telling and that I was going to the police for help. So I had consequences on my side of things, and I had to fight these inmates. When I became physical altercations with these inmates, they returned my radio. When they returned my radio to me, it did not have my name and number on it. I immediately took that to my unit team and said, I have my radio. It was returned to me, but I need my name and number put back on it. Can we please do away with the property claim? He's like, yes, this doesn't happen often. I'm going to go get your name and number put back on it today. He took it to the property officer, which has denied giving me my property back. As you guys can see, you said that you have all my documentation. All my documentation has my serial numbers of my radio on there. So they didn't scratch the serial numbers off, just my name and number. Those serial numbers still match my radio, and I shouldn't forfeit it because the property officer doesn't want to look into issuing it or how it's issued. From my understanding, El Dorado Correctional Facility has the problem of it was not purchased. My radio was issued by Hutchinson Correctional Facility in 2013 by EAI to take care of a property claim, which is in the IMPPs. When they give you merchandise that's been donated or that they have extra of in lieu of your property claim, it becomes your property. I've had the radio for 10 years through movements to Lansing, Hutchinson Correctional Facility, El Dorado, Ellsworth. Never did I have a problem until this property officer said that I didn't purchase it. In my property log, it says right in there, issued for property claim for EAI. Now, these radios are grandfathered in. You can't purchase them anymore. Deputy Warden Howes, when my family got involved and started contacting them and finding out, you know, what the big deal was and showing our receipts and the proof of radio, the deputy warden at El Dorado tried to offer me a different radio, saying that his property officer had destroyed my radio. So he tried to offer me a ClearTunes radio, which was of lesser value, and the make of it is, the quality of the item is not the same. The radios can be sent in to be fixed by the company. It states in the IMPPs that if a claimant is eligible to have electronics, if property is confiscated or donated is available at the facility, the warden or superintendent could produce these amounts up to the claim amount. When using electronics to resolve the claim, the warden can authorize claim amounts up to the cost of one new television or one new radio. The facility shall maintain a file containing copies of other offenders, acknowledgments in writing, and claims settled through the commissary or electronic receipts associated with the claims.
Okay, thank you. Yeah, Mr. Jones, I just want to kind of get to the crux of everything.
Yes, ma'am.
And so let me just ask you a quick question. Your $109.83, is that to repair or replace the radio? The amount that you put on your claim, to repair or replace?
Yes, ma'am.
Is it to repair or is it to replace?
Either one. I could send it in and get it repaired.
But didn't you say that it's not available anymore to purchase?
You can purchase them, a new one on Amazon for $87.
Okay. All right. Thank you. That answers my question. I think we'll hear now from the Department of Corrections attorney. Okay. And we'll, Mr. Bushbaum, and we'll see their response. And then we may have another question for you after that. So Mr. Bushbaum, go ahead, please.
Thank you, Madam Chair. Mr. Jones requests $109.83 for property loss. He claims Hutchinson Correctional Facility staff did not return a radio he had sought to be remarked. On January 31st, 2023, Mr. Jones filed a property loss claim in which he states one or more residents stole his Sangean radio. The property claim was initially denied because no purchase history could be found for the radio. A full review of his purchase history since 2010 found no purchase of a Sangean radio or a payment for the amount stated. It was determined that the receipt included in his claim was provided by a family member. Sometime after the claim was received, the Sangean radio was returned to Mr. Jones by the resident that stole it. This rendered the facility claim moot. Upon regaining the radio, Mr. Jones then gave it to his unit team manager to be remarked with his information, as he claims it had been scratched off. The UTM, upon inspecting the radio, saw that the power cord and port to the radio were damaged, and the cord had been shoved into the body of the radio to keep it attached. The radio was identified as a model that is no longer allowed for security reasons. The UTM, for these reasons, did not return the radio. Rule 2 of the Joint Committee provides that a claimant should first exhaust any administrative or judicial remedies that may be available. The only claim regarding the radio was one stating that it had been stolen by a resident. Mr. Jones did not file a property claim to appeal or investigate his UTM's unwillingness to return the radio. As such, he did not exhaust his administrative remedies. As previously mentioned, the radio Mr. Jones was banned from facilities due to posing a security risk. The face of the radio was composed of plexiglass, which produces shards when smashed. These shards have been made into various forms of contraband and are typically used for creating stabbing devices. These radios are therefore classified as a security threat. Although his radio was taken a year after the initial ban on them, the item is still prohibited. Additionally, the electrical cord damage was also considered a safety hazard, as wires were protruding from the base of the cord where it met the body of the radio. It appeared that repeated attempts to force the cord and wires into the body of the radio made it an electrical hazard. Regardless of whether the radio could be fixed by the manufacturer, the radio itself was an unauthorized item. Deputy Warden Howes offered to replace the radio with one that was compliant with facility standards. Mr. Jones refused to accept anything other than the radio that was taken. Additionally, in his remarks, the claimant states that EIA apparently gave him the radio and that he did not purchase it. However, he includes a receipt for $104.75 for a Sangean radio from August 3rd, 2015, included in his legislative claim. So it's a little uncertain as to whether he did or did not purchase this radio. However, a receipt does exist. In the event, we go with the claimant's version of events in that he did not purchase this radio. He is out no loss. He was, the deputy warden attempted to give him a replacement radio with the same functionality as the original, just within facility standards. And for those reasons, the department requests that the claim be denied.
Okay, thank you. Representative Mon, you have a question, or would you like to ask
I do have
Mr. Jones a question?
Well, Ms. Jones and Madam Chair, I apologize with the judiciary websites being down. It's hard for me to research this stuff ahead of time.
Imagine.
And so I think it's important for me to ask the,
please do.
the questions. Mr. Jones, my name is Carl Mon. I have been an appellate attorney and a criminal attorney for quite some time. Your name is familiar to me. I know it's not necessarily an uncommon name. So I just wanted to understand, just get your input as to whether or not I've represented you, and or if you have a brother named Justin, who I may have represented as well. I just wanted to kind of get some confirmation from you as to whether I may have represented you in the past.
Mr. Jones, did you understand that question?
Yes, ma'am. I don't have a brother. I have one sister named Stacy, and I do not believe that you represented me in any capacity in appellate.
Thank you, Ms. Jones. That's all I need to know. Thank you.
Thank you. Thanks. Okay, committee. Any other questions? Yes, Representative Vaughn. Is that it's for Mr. Jones? Representative Vaughn has a question for you.
Hi, Mr. Jones. I just wanted to confirm whether the deputy warden did in fact offer you an alternative radio, and if so, if there was a reason that you did not want to accept that radio in lieu of the one that was broken, that was confiscated.
Okay. As the council has stated that we can't purchase those radios anymore, but we can still have them. They're grandfathered in. Everybody here still has their radios. It makes it seem like the state's saying that they've been taken from us and we can't possess them. Everybody that still has purchased those radios and have them can still have them. It's called grandfathered in. And they're very nice radios. They're like a Bose entertainment center compared to something you'd buy from the dollar store. The deputy warden found it deemable in my complaints and his investigation to offer me the radio, but he didn't find it far enough to correct his officer's behaviors. Why did she throw my radio away or not allow me to try to send it in to get repaired? And that was my question for the deputy warden. It's like, I'm willing to pay my own money to repair these things that somebody else has done. I don't see me having to forfeit my property or my privileges when I did nothing wrong and I followed procedure 100%. I even asked for my unit team's help when, I could have put my name and number back on my radio myself, but I didn't. I tried to do the right thing. And I've been opposed by the state this whole year for doing the right thing. and trying to follow the property procedures. That's what that paper trail is for, and all the emails back and forth from my family. It's like, the truth is the truth. My paper trail is there. I don't have to add anything to it or discuss anything. It's all right there. I've done nothing wrong to deserve my privilege taken away, and I shouldn't have to accept something of a lesser standard or lesser value when I've done nothing to lose that.
Okay, Representative Vaughn has a follow-up question.
I thank you for that response. I would be interested in Mr. Bushbaum's response to that, if that would be all right, Madam Chair.
Thank you. 3 quick things. First of all, there is no grandfather procedure for these radios. They were banned about 2 years ago from multiple different facilities across the department, and to my knowledge, they're banned at all the facilities right now. As to his claim that multiple residents have these, that is factually incorrect. Although there was not a sweep upon a ban being made by the facilities, over time, as they've been found, they have been discarded and replaced according to the deputy warden's directions. And aside from that, even if he did have it fixed, again, he could not have it. It's a restrictive item. So, and I did review, I mean, dozens, probably over 100 emails back and forth about this issue between his family and the department thoroughly. There is no mention of anyone even offering some kind of a grandfather clause for this radio. So.
Yep.
Thank you, Mr. Bushbaum. Mr. Jones, I did have one more question for you, if I may. There is a note in your packet in regards to legal representation indicating that Michael E. Francis was willing to represent you regarding this matter. I was just wondering if he was representing you and if you had any sort of existing litigation or open case outside of this claim here today.
Well, I've been having some medical issues, like stemming from this, and basically he was helping me with that, man.
Okay, thank you for clarifying.
And also,
just hang on just a second, Mr. Jones. Committee, do you have any other questions? Anyone else? Okay, Mr. Jones, this is your last, go ahead, but kind of your last comment. I think we're finished with the questions that we have for you. So you go ahead and finish up.
okay. If I would like to, if I could enter into the record, I'm in my unit team's office here at HCF. My name is Miss Gillespie, and I'd like to ask her if there's an active ban on San Jean radios. Are they confiscating them? Can you clarify that, like how the prison is treating those radios? Because the comment that was made that they're not allowed and we can't have them is not a factual thing, because they're on inmates' desk right now.
Okay,
Are
so
they not?
I'm going to allow the supervisor to say something. If you would please identify yourself, because I do feel like it's relevant to our discussion on this issue. But identify yourself, please, and just make a quick comment.
Okay, my name is Stacey Gillespie. I'm a corrections counselor at Hutchinson Correctional Facility, and I oversee on my caseload. So, to my knowledge, I don't believe that there are any specific policies, regarding grandfathering. I would have to follow up with our legal department. So I can't make a comment necessarily on grandfathering, but I do know that general policy, whenever they are going through, if they do a shakedown or anything like that, if there are items that are prohibited, generally those things are confiscated. I don't know the circumstances policy-wise on a grandfathered clause, though.
Okay,
Are
thank
they
you.
taking?
Committee, do you have any questions? Senator Haley has a question.
Thank you, Madam Chair. Can you hear me? I guess the question is, are you aware, ma'am, of other such items, radios that are still in population now? I guess he said it was like a Bose. I mean, are there similar radios still in population, to your knowledge?
I personally have not seen any, but we have residents that have been incarcerated for decades that may be in possession of that were previously allowed. Unless they did something that would lead to a situation where those items are confiscated, those items for extended periods. And it extends just even beyond radios. It's you know, pictures and mail and other items that they may have been allowed to receive before but are not allowed to receive now.
Okay, thank you.
Thank you.
Thank you.
Madam Chair.
Mm-hmm. Okay, any other questions, committee? All right, so Mr. Jones, the committee will take some time and consider your claim, and our written decision will be provided to you within 21 days.
Okay.
You understand?
Thank
Okay.
you, ma'am.
Thank you. Thank you. Bye-bye.
Madam Chair. Madam
Okay,
Chair.
committee, yeah, okay, Representative Vaughn and then Senator Haley, yep.
Sorry, would it still be appropriate to ask Mr. Bushbaum a follow-up question? So I was going back to the materials. I wanted to confirm whether or not Mr. Jones purchased the original radio, and if it was purchased, what's the value of the new radio, and trying to understand what the difference in those values might be.
Okay, so he alleges two different things, whether EIA gave it to him at Hutchinson Correctional Facility or whether he purchased it. He supplies a receipt. When a complete review of his purchase history, no such record exists of him purchasing a radio or for an amount of the radio in the receipt, $104 and something odd cents. However, we believe his family member, either his mother or his sister, purchased the radio and then gave it to him, which, again, it wasn't purchased through the canteen, so there's some issues there, but we're willing to ignore those for now, for expediency. And it's up in the air whether his family purchased the radio. He himself absolutely did not. It had to have been either his family or if he claims EII, but I sincerely doubt that since there is a receipt, if that helps. And as to the amount of the radio that was offered to him, I do not know that amount. I just know that the radio was of the same ability as the radio that was taken. The actual dollar amount of it, I'm unaware of that.
Thank you.
Okay, and I will just note that we have taken into consideration receipts that family members have given us before in previous years. So yes, Senator Haley.
And thank you, Madam Chair. And along that line, why is this particular radio banned now? Does it pose is it a value risk or is it a security risk? I mean, why is it that this item is off the list?
Yeah, absolutely, Senator. It is a health and safety risk. This radio specifically has a plexiglass screen on it that's rather large, and when thrown at the ground or broken in any way, it does shatter. And residents will take tape and wrap it around one part of the broken plexiglass shard and use it as a device to injure other correctional officers or other residents. So they have been banned for this particular reason, and that's why this radio was.
Thank you.
Thank you. Committee, I think we should move on. We have two more from Mr. Milo, and then why don't we, after we hear his, we'll stop and we'll do some decisions. Okay, but let's go ahead and make a phone call to Mr. Milo.
Morning, my name's Mike Ditch. I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Keyshawn Milo. Is he available?
He is. Hold on just one moment. I'll give him the phone, okay? Hello?
Yes, hi. Mr. Milo, is that you?
Yes, ma'am.
Okay, thank you. This is Susan Humphreys, and I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing, first of all, your claim number 7365 in the amount of $234.07. You're on the speakerphone with the committee here in the State House. The committee has been provided with all of your documentation for your claim. And I'm going to give you the chance in just a minute to tell us anything else that you would like us to know. Then after that, we will have a representative from the Department of Corrections tell us their response. And then when that is completed, the committee will take some time and consider your claim and provide you a written decision within 21 days. Does all that make sense to you?
Yes, ma'am.
Okay, thank you. So, Mr. Milo, go ahead and tell us about your first claim, which is the one that was for $234.07.
Yeah, I have wrote even in like with a Form 9 with that property claim, saying if being rewarded on this claim, I would like a TV, and I even mentioned this, a TV and a radio, and they ignored that claim and just sent me money. And I constantly kept trying to talk with like, why not give me property? Why are you trying to give me money? I dealt with this situation with set off. Somehow they when checking to try to figure out how they was able to send my $30 from the canteen to set off, we end up finding out that CIB never received the check, that the check was sent straight from, I guess, the facility to set off. So to avoid any of that happening again, and I still don't know why it happened because they haven't wrote me back, even though I wrote them before the 15 days. But I didn't want to deal with this whole headache. Like, I just wanted property, and she wouldn't give it to me, the deputy warden. So when I actually seen the warden a couple months later, I explained him the situation, and even he was saying, why not give him the property? We literally got the property, what he's asking for, in A&D. And when I gave everything back to the warden that I had, because I seen him at a summit the next day and gave him the copies, he said he'd look into it. And then I got a response instead, not from him, but the deputy warden, saying that this claim is final, is nothing I'm doing about it. So it just left me with no choice but to send and submit everything to the committee.
Okay, thank you. Did anyone on the, well, we're going to hear first from Mr. Bushbaum from the Department of Corrections. Go ahead, Mr. Bushbaum.
Thank you, Madam Chair. Mr. Milo, is it Milo or Milo for clarification?
It's Milo.
Thank you. Mr. Milo requests $234.07 for lost property. He alleges that Hutchinson Correctional Facility has not provided compensation for an approved facility property loss claim. On January 18, 2023, Mr. Milo filed a property loss claim in which he states multiple items of property were stolen from his cell due to a staff member leaving his cell door open. The UTM recommended the claim for approval, and it was approved by the facility for $234.07. In his present claim, Mr. Milo states that Hutchinson staff had not provided compensation in the manner he requests. Instead of depositing the sum into his centralized inmate banking account, as required by IMPP 01118, Mr. Milo has demanded that property similar to what he lost be given to him from the facility's admissions and discharge office. This office is where the resident and facility property are stored. Mr. Milo has refused to sign the required W-9 form for the award to be paid. He explains that he does not want his money to be taken to pay any debt collectors, which he claims garnish deposits made to his resident account. Even if Mr. Milo's garnishments are not court-ordered, such as an administrative or tax garnishment, they are still imposed during his residency. His assertion in his legislative claim that unpaid court fees resulting in garnishment do not have to be paid until his release from custody is incorrect. While IMPP 01118 does allow for property claims to be settled by replacing unissued canteen items, it also states that the claim must be valued at $50 or less for substitution to be an option. Again, his claim is $234. This claim exceeds that amount. IMPP 01118 also states that the warden may offer substitutions for certain electronics, but there is no obligation to do so. It is entirely up to the warden's discretion. The only avenue remaining under department procedure is for a monetary credit to be deposited into the resident's CIB account. Mr. Milo's interest in avoiding his debts is not justification for the department to violate internal procedures. Additionally, it is worth noting that if the Joint Committee approves this claim, the state will compensate Mr. Milo with a monetary credit to his account. The very thing that Mr. Milo is trying to avoid with this claim will happen whether the facility pays the claim or the Joint Committee does. Even so, KAR 44-16-105 and IMPP 01-118 state that property claims shall not be paid unless loss or damage directly resulted from staff negligence. Since no staff negligence has even been alleged, and because approving this claim would compensate Mr. Milo twice for the same property claim, the department recommends the claim be denied. Thank you.
Can I say to that?
No, hang on just one second. I'm gonna see if the committee has any questions. Committee, do you have any questions first? I do have a question, Mr. Bushbaum. I'm looking at the letter from S. Roach on January the 26th, 2023. It says, upon completion of the investigation, it is apparent that the resident Milo's property was stolen from his cell because of staff negligence. And did I understand you just to say there was no staff negligence?
Madam Chair, there is no staff negligence for the failure to pay the claim. The claim, the original property claim that this legislative claim arises from, was approved for staff negligence. However, his new complaint that the award wasn't appropriately paid is a different thing altogether.
Okay, I appreciate that differentiation. The fact is he doesn't have his TV and his radio because of staff negligence. I'm just making that point.
Yes, Madam Chair.
Okay. Committee, do you have any other questions? Representative Rajas?
Well, thank you, Madam Chair. Is it simply a matter of thinking that if this money's deposited in, it'll be used to pay support back taxes rather than, is that what we're trying to avoid in thinking that that will be enough to replace the items that were
yeah.
So it's on Mr. Jones. He says we'll initiate it, but the state does claim fault, correct?
Mr. Milo, his claim was approved, and yes, the only thing that is preventing the facility from paying the claim is that he refuses to sign the W-9 form because he doesn't want any money that the facility does pay towards the claim to his account to be taken for debts that he owes. He states this, I think, 4 or 5 times in his legislative claim.
But, so what he's wanting is just the state to replace it with no paper trail.
Essentially, yes, Representative. He doesn't want a monetary credit applied to his account because that credit can then be, through garnishments, a portion of it can be taken to pay debts that he owes, either to the state or to an agency of some kind. So he wants physical property to avoid that.
Is there any other way to pay residents when they have a claim besides just into their account?
The only other way is, as I stated, through property. However, the amount of property that can be substituted has a $50 cap on it per claim. As this is over $200, that's not an option. The only way this claim can be paid from the department's perspective under our procedures and regulations is to be credited to his account, and that is very standard.
Okay, thank you. Merle, did you have some clarification?
Yeah, I just wanted to clarify, and Mr. Bushbaum spoke to this, but I can clarify for statutes for the Claims Committee, Mr. Bushbaum is correct that set off or any debt, statutes for the Claims Committee specify that if a payment is made, garnishment for debt is taken out of that payment, even if awarded by the Claims Committee.
Okay, thank you. Any other questions first for Mr. Bushbaum? Any other questions for Mr. Milo? Mr. Milo, did you want to say something else? I feel like you had something else you wanted to say.
Yes, ma'am. They got it all wrong. It says unpaid court order restitution. I don't owe court order restitution. I owe court fines and fees, which I'm also already making payments on too. They send in the payments to any other court fines and fees, and it's not in there. It doesn't say it's any other court fines and fees. Restitution and court fees is 2 different things, you know? So I'm still in the process of trying to figure out who gives set off authority to just take the checks, because accountant forwarded to CIB, which CIB sent me a letter, which I sent to y'all, that they said they didn't even know or had nothing to do with it. So it was sent from this facility straight to set off. So I'm still trying to figure out how and where is they getting authority to take that, because it's not unpaid restitution. And it's not me avoiding court fines and fees. Or I didn't owe these fines and fees when I paid for my TV and I paid for my radio. So just the same way how I paid for my TV and radio, I should be able to get that property. They give property to people all the time when it's available. It also got that option. So when the option of TVs and radios actually being an A&D that they can give me, and choosing to ignore my request and just give me that, it feels like it's more retaliating for
Okay,
the staff losing my stuff.
So, Mr. Milo, thank you for that explanation. I do want to clarify, this committee specifically, in our purview, it's our ability to award you monetary. Just monetary. That's it. We can't make them do something else. This is kind of what we're set up to do, is to either award or deny claims on monetary amounts. So just so you know that that's kind of where we're at. Your argument would be with someone else. But also, we're going to just clarify that statute or is it a regulation that you were just talking about? We have
Yes.
our
I believe I
legislative
sent that
research.
with y'all.
Okay, hang on. We're going to hear from Merle about a clarification on that regulation.
Yes, Madam Chair. KSA 26920B states, when an inmate owes an outstanding unpaid amount of restitution ordered by a court, the Secretary of Corrections shall withdraw from the inmate's trust as set off money received by the inmate from the state as settlement against a claim, or money received by the inmate from the state as a result of settlement and a final judgment.
Okay, so it does mention restitution.
It says, when an inmate owes outstanding unpaid amount of restitution ordered by a court, the Secretary of Corrections shall withdraw from the inmate's trust account as set off. So
Okay, thank
he
you.
owes restitution, he has to pay.
Okay, thank you. Okay, so Mr. Milo, we're going to talk about that. Again, what we can do is deny or accept a claim, a monetary value. But right now, I'd like to move on to your next claim, which is claim number 7366.
But you
amount
hear
of
he just cleared it up. Restitution. I don't owe restitution. So that's
And-
where I'm lost on how they are able to take my money with
Okay.
me not owing restitution.
I
These are
understand
two
that. And of
different
course,
things.
as I mentioned, that's really outside of our purview of this committee. So I think that's something, but we can talk about that. But for now, what we're going to do is we're going to move on to your next claim, which is 7366, a property loss in the amount of $118.12. Could you tell us about that? What would you like us to know about that one?
Well, in my statements, it was just thrown out after the report already acknowledged staff negligent on it. It was thrown out without no explanation of why or any of that. It was just dismissed. And again, they doing the same thing they've been doing, not telling me nothing, just doing it. So I'm rewarded on the incident report, but the property claims say different. I mean, I guess you can do that, or it's IMPP saying that you can do that. Well, I don't know explanation on why the property claim don't match the incident report. I don't know.
Okay. This is an MP4 player, and is your complaint the same as it was in the previous claim, or it's something different?
No, you said the name?
I was just trying to clarify what your complaint was. It's $118.12, and I'm reading the documentation we have, and it seems like it's an MP4 player.
Yes, ma'am.
Okay, and your complaint is the same it has to do with the money being deposited in your account, or is it a different nature of the claim?
I would have liked the property, but you already explained that, so I'd rather
Okay.
get past this now.
Okay. All right. So we're going to hear from Mr. Bushbaum from the department on this particular claim number 7366.
Thank you, Madam
Okay.
Chair. And just as a quick overview, the claim in the second one, 7366, is a different fact pattern. They're very similar, but they are indeed different from 7365, the previous claim. Okay. Mr. Milo requests $118.12 for property loss. He alleges that Hutchinson Correctional Facility denied his property claim after his UTM, unit team manager, recommended it for approval without notifying him. On December 17th, 2022, Mr. Milo filed a property loss claim, in which he claims an MP4 player and TV remote were stolen from his cell due to a staff member leaving his cell door open. His UTM recommended the claim be approved, but the claim was denied by the deputy warden due to a finding that security staff was executing their duties to the best of their ability. The secretary's designee, who concurred with the deputy warden's findings, added that the officers were working as efficiently as possible to return residents to their cells at the time of the theft. The UTM and facility came to different conclusions regarding the security staff's actions because they had different perspectives. The UTM reviewed security footage of the resident stealing Mr. Milo's items and observed no security staff stopping him. The deputy warden had a larger field of view and was able to see operations of the facility as a whole. It was evident to her that under the circumstances of a mass movement, the security staff was executing their duties to the best of their ability. For context, on the date of the incident, December 16th, 2022, Hutchinson housed 1,772 residents, with the majority of them, around 900, housed in the central unit where Mr. Milo resided. During a mass movement, hundreds of residents are moved from their cells to a destination, typically chow, showers, or the yard for recreation. Residents are randomly checked for contraband by officers, walk through detectors operated by officers, and are being guided by officers. This process requires substantial effort by the security staff. As a cell block is cleared of residents, the staff works methodically down the rows as residents leave and return from the showers. On the date in question, there were fewer security staff available for this task than usual, and only 2 officers were available to return residents to their cells from the showers. One resident was able to slip through to the first floor where Mr. Milo's cell is located, used a broom handle to knock the MP4 player and remote off of Mr. Milo's bed, and made off with them. The cell door was closed and locked. Why that resident risked sneaking all the way to the first floor and then specifically seeking Mr. Milo's cell remains uncertain. What is certain is this was not the first time Mr. Milo's unsecured property was stolen from the top of his bed despite his cell being locked. The previous claim by Mr. Milo, in which we just heard, stated almost the exact same scenario, electronics stolen from the top of his bed, but the thief was able to simply reach in and grab the property from his bed. The claimant contributed to the loss by leaving his electronics on his bed for a second time, where they could be seen and retrieved by other residents when security staff was maintaining order during a mass movement. The understaffed security officers did the best that they could under the circumstances. Order was kept and safety was maintained for hundreds of transfers. KAR 44-16105 and IMPP 01118 state that residents own property at their own risk, and claims shall not be paid unless loss or damage directly resulted from staff negligence. The claim fails to show that Mr. Milo's stolen property was the direct result of staff negligence. Based on the foregoing, the department recommends that the claim be denied. Thank you.
Committee, do you have any questions for Mr. Bushbaum? Representative Mon.
Mr. Bushbaum, you said it's not the direct result, but is it a consequential result of staff negligence?
The UTM certainly thought so, Representative, in his response to the initial facility claim for the property loss. The deputy warden had a different interpretation, in which one I also ascribe to, in that the officers on staff did everything that they could. They were doing their jobs correctly. There was not a staff member that did something that was negligent, if that makes sense.
Okay, any other questions? Does anyone have any questions for Mr. Milo? Okay, Mr. Milo, we will take into consideration everything that we have heard, that you have told us, And we
Can I say
will,
something?
yes, let me just finish. We will give you our written
Okay.
decision within 21 days, but you may wrap up with your last comment.
Thank you. All right, so it's not staff negligence when you have two COs that's supposed to be escorting, making sure the inmates get to their room, but one slipped right past the CO, gets up, steals something that, for the record, they keep saying the door was open. Never in the reports you see none of that. I don't say that the door is open. It's bars. You know, able to grab a broomstick from where the porter stuff is at, reach in and grab something out of my room, and that's not staff negligence. So I mean, at this point, it just seems like, what is staff negligence? Because we blame a lot of stuff on overstaff and this, and you know, if I'm able to slip past an officer or attack an inmate or any of that, is not the officer's fault for not doing his job. And it wasn't showers, it was chow. So limited people come out. It wasn't like they was dealing with 100 people. It's just one run at a time. People don't come out. It's not a wholesale house. One run. So that's the reason why they do it like that, because one staff is making sure people are being directed where they need to go, and another staff is unlocking the doors, getting the inmates out. That's the reason why they got two staffs, and the reason why they run one run at a time.
Okay,
So if
Mr.
this,
Milo, I think
yes,
we understand the situation, and we will certainly take all of that into consideration. So I appreciate it. The committee is here again.
okay.
You're on the speakerphone, and we will take all of that into consideration as we make a decision. So really, thank you. We appreciate it.
All
Okay.
right, thank you.
Bye-bye. Okay, committee, we're going to take some time right now and try to do just a few recommendations and get that over with. And then we have 4 coming up, and one of them is in person before lunch. So sorry. Okay. The one that we've not done yet, we're looking at claim number 7358. This is the one with the beads and the tote in the A&D area. Does anyone have a motion on that? Representative or Senator Dietrich?
Thank you, Madam Chair. Based on the information that we received and this thorough search of the area, and the tote and the beads were not found, I'm going to move to deny claim 7358 in the amount of $450.
Do we have a second? Second by Representative Rajas. Does anyone have any discussion on that? No discussion? Okay, all those, we have a motion on the table to deny claim number 7358. All those in favor say aye.
Aye.
Opposed? Okay, claim number 7358 is denied. We're moving on to claim number 7359. This, if you remember, was Mr. Gray, and it had to do with photos, lingerie, swimsuit, that kind of thing. Do we have a motion for that? Senator Dietrich.
Thank you, Madam Chair. I'm going to move that we deny claim number 7359 in the amount of $145.80.
Do we have a second? Representative Mon seconds. Any discussion? Okay, motion on the table to deny claim number 7359. All those in favor say aye. Opposed? Okay, so claim number 7359 is denied. Okay, we're now moving on to Mr. Jones. Claim number 7362. This was the radio, the grandfathered in, if you recall. Do we have a motion on that? Representative Vaughn?
May I make a point for discussion? Yeah. So this is one I'm kind of conflicted on, because it was purchased property, whether it was purchased by his family or himself, at a time when it was allowed under the rules of the facility, and was later confiscated because it was it had become a prohibited item. I would be interested in paying the claimant the difference between the value of the radio and the radio that has been offered to him through the facility. But unfortunately, we don't know what the value of that radio is. So that's kind of where I'm stuck. Because it was purchased property and it was confiscated, not through a fault of his own, but a changing of what was allowed within the facility. And it had, it was a safety hazard. I know that was part of the issue as well, but so that was just a point of discussion I wanted to make. I think it is a valid claim. It's just how much should be paid to the claimant, especially since he has been offered a replacement radio. He just doesn't feel like the value of that radio is the same of the one that had been confiscated.
Senator Dietrich.
Thank you, Madam Chair. And I too had a thought about this radio. So the claim was approved in the sense that the claimant was offered a replacement radio.
In that sense, yes.
Yes,
Senator.
and then he declined that because he wanted the same radio. So really the monetary amount is probably a moot point here. What I would like to ask is, and perhaps you all can help me here, can we make a motion to approve the claim procedure so that KDOC would be allowed or encouraged or whatever to provide that replacement radio one more time? Because we really don't have a dollar amount, and this isn't, and it's already been approved. It's just he's denied it. Or refused it. I shouldn't say denied it. What are your thoughts?
First of all, Mike, and then
I would suggest you do it in the form of just a motion, not to approve or disapprove, and that you've got a representative of the Department of Corrections here. He could convey the message, but it literally is just a message to try again.
Yeah, so could we move to deny the claim, but encourage KDOC to offer a replacement radio one more time?
You can do that.
Mr. Bushbaum.
Thank you, Madam Chair. We're absolutely willing to do that. I would also just like to make note, so the committee is aware, the receipt that the claimant provides is from 2015. So under departmental policies, depreciation would be 50% since it's over 5 years old. So that was also kind of the calculus that went into whatever dollar amount the replacement radio would be worth. So just, it wouldn't be a radio that's equal to $109, the original price of the item. It would be whatever 50% of what it is now. That helps.
Representative Vaughn.
Thank you, Madam Chair. So an unrelated case, but with claimant Milo, I thought depreciation was listed at 10% and not 50%.
Yes, Representative. It goes by year. IMPP 12 or 01118 states that depreciation is 10% for every year that the claimant has had the item.
Thank you.
Okay, so do we have a motion on the table?
I'd be happy to make that. I think I remember what I said.
I'm sorry, Senator Haley.
Because I think I know where Senator Dietrich is going. Thank you, Madam Chair. I'm concerned, I guess, about the original point that Representative Vaughn did raise, is the taking of property of a particular value by the department because of the shift in policy where it was legally held, and then it's taken, and then that value is not replaced, whether it's with a new radio, whatever it is, of not the same value. But the money does matter. I mean, especially in this tight environment where the quality of something may have been. And I would hope that we would somehow supplement the replacement radio, which hopefully the department will offer again to to the claimant, but also the dollar figure for the loss, depreciated though it may be over time, for for shifting, for changing all the rules, and then being able to deprive someone of a more valuable property. Just throw that out for
thank you.
consideration. Thank you.
Senator Dietrich.
Bring this correctly, that radio was stolen and then it was found.
Correct, Senator.
And then when it was found, it was deemed to be, no longer, it was prohibited now from being in an inmate cell. So So even though, I mean, it was negligence in the fact that, that it was or stolen, but it was found. So I think the monetary issue, Senator Haley and Representative Vaughn, I mean, it had been used for many, many years. It wasn't lost for 9 years, so, and it was purchased in 2015. So I just like to get the guy a radio, really. And if they've offered to replace the radio and he's denied it because he thinks, we're going to be able to replace that radio, or that we'll give him the cash and then he can buy the same radio, is a moot point. He can no longer have that radio. So I'm just trying to think about what's fair.
I also might add, I'm just curious what the policy is. Let's say, people have the radios because they haven't done a sweep, they haven't been moved, but if they find them, they take them. And do they offer to replace them in that case?
Absolutely, Madam Chair. Yes.
They replace them with what? The same?
A radio with the same functionality as the radio that was taken.
Okay, so that could be part of our request, is just to make it clear that we're talking about the same functionality.
Absolutely, Madam Chair.
Okay, Senator Haley.
Okay,
Yes.
I know, but a radio is not a radio, it's radio. There's sound quality and what have you, and that's the thing. I mean, there may be a superior in terms of sound or even range, radio that can catch a better signal. I don't know. That's the concern, is the quality of what the replacement that is given because of the shift in policy. And understanding that there are some concerns, as you expressed, Mr. Bushbaum, with this particular radio, how they're able to be perhaps manipulated and broken and used in disadvantageous, if not dangerous way. But the value of it may be beyond the fact that a radio is not always just a radio. And I think that if you take a subsequent radio, if there are more that are found, and that they're now violative of the policy because of the shift in the policy, there should be some compensation afforded to that claimant, that inmate, beyond the actual replacement radio itself. Anyway.
Senator Dietrich.
Okay, I'm going to try this motion one more time, taking into consideration what we've discussed here. So I'm going to make a motion that we deny claim number 7362, but that we ask Kansas Department of Corrections to offer a replacement of similar quality to Mr. Jones.
So are you changing the word from
functionality to quality? Similar quality. Hoping.
You'll second? Okay, seconded by Senator Haley. Representative Vaughn, do you have a comment? Representative Vaughn?
It just, as a matter of discussion, if we just granted the claim, you could buy a radio of functional or equal quality on its own. I do have the same concerns as Representative Vaughn and Senator Haley of it was property that he had. Yes, it was stolen, but it should have been returned to him rather than just be contraband. And I think if we just granted the claim, he could either choose to buy a radio or not. And so I understand where Senator's going with this, and I tend to agree. But on the other hand, I simply...
Okay, Senator Dietrich will respond.
Right. So the reason I went through saying that we're going to deny this motion, because he does want the dollar amount, but he also wants the same radio that he can't have. And so I thought we would just circumvent his trying to order that same radio and get it delivered and then get it confiscated, and here we go again. That's why I couched it that way. Maybe I'm overthinking it.
I get it. I just I don't know.
Did you want to make a substitute motion?
Well, there's a motion on the floor, but if the senator would accept a substitute motion, I would substitute with the motion to simply grant this motion, grant the claim, let him buy the radio that he can buy, and go down that road.
Okay, I think the procedure is that there's a substitute motion on the floor. And so do we have a second? Okay, I don't think we have a second. So we'll go back to the original motion. Yes, Representative Vaughn.
Thank you, Madam Chair. As a point of discussion, an alternative substitute motion could be to deny without prejudice if he were to receive a radio that he felt was not in fact of equal quality. It would allow him to bring the case back, which I don't know, is that something that we would like to do as a committee? I think that's the question on the floor, but so that's just another point that I would like to make. I don't know that I want to bring that motion, but if that was something that someone else was interested in, point of discussion.
Okay, anybody taking that one? Okay. All right, then we're going to go ahead and vote on the original motion, which was to deny the claim, but encourage the department to offer this time a radio of similar quality. Yes. Oh, we did have a second. Thank you. Senator Haley did second. Yes. Yeah. Okay. You heard the motion. All those in favor say aye. Opposed? Okay, I'm gonna have to have a show of hands. All those in favor, please raise your right hand. We have 3. Those opposed? 2. The motion passes. Yes.
I will say I am concerned. I certainly support the intent. I am concerned about the ambiguity of what we did pass. Encouraging the department to replace it with a similar quality is a huge loophole, but I certainly hope in good faith that the department takes it under judicial notice, if you will, that we really do hope this man gets a superior replacement.
Thank you. Thank you, Senator Haley. Okay, we're going to move on to claim number 7365. This is the one with a TV and a radio. It had to do with the money being deposited into his account and then being garnished. I do have a question before we discuss this, Mr. Bushbaum, on you heard the statute that Merle read, and it did say restitution. Do you have any comment on that?
Madam Chair, it's CIB's policy when I asked their deputy director whether they distinguish different types of garnishments. They do not. Under this, yes, court-ordered restitution is mandated. However, CIB's internal policy appears to incorporate other types, such as an agency garnishments as well, for taxes and things like that. I do not know what his specific type of garnishment is that he is concerned about, and that was not relayed to the department.
Is that in written form, or is that just a practice?
I do not know, Madam Chair.
All right. We'll see if we have any counsel from our revisor or research.
Madam Chair, I'm not an expert in this, but I am aware that there is other statutes that generally govern garnishing items if there is debt owed to the state. So I read statutes specific to the claims, and that relates to restitution. I do believe there are other general statutes that if you owe a debt to the state, some portion of that can be garnished, whether it's restitution or child support or other items.
Okay, thank you. Thank you for that clarification. Committee Representative Vaughn.
Thank you, Madam Chair. On this one, because the claim has been approved by the facility and would be paid either by the facility, or if we were to approve it, it would be paid to the CIB account where this garnishment will take place. I would move to deny this claim because it will be paid and has been approved, and the location of that payment or the account where that payment would be made would not change whether or not we pay the claim or not. So I would move to deny.
Okay, thank you. Is there A second, or Representative Vaughn, you have discussion? First,
Oh.
let me just say, is there a second? Okay, we'll have a second, so then we're there, and then discussion.
I was going to suggest a friendly amendment of denied without prejudice, because if it doesn't get paid, maybe he can come back to us. So
And a point of discussion is, did he reject that offer and that's done? But, so if we deny this claim, there's no offer still on the table?
No, Madam Chair. The resident accepted the settlement. He has refused to sign the form that allows the payment to be made to him. And until he signs that, the facility is simply unable to deposit the amount in his account.
Okay, so another reason it seems like this is kind of still in process somewhere else. It's not really last resort, I would say. I will, just one other point of discussion is that he doesn't have his TV and radio, but he is getting his debts paid because of this. So there is some benefit to him, even though it's not the immediate benefit of a TV or radio. You are getting out of the hole, per se. So, okay, so we have, yes. Mm-hmm.
You, Mr. or Madam Chair, and Mr. Bushbaum. So I mean, it's basically a standing opportunity for him to sign the form, the W-9 or whichever form it was, in order to receive the payment. There's no end date by which he has to sign that form, or does that expire at some point?
It does not expire, Representative. The settlement is there until he chooses to accept to sign the paperwork.
Okay, so we have a motion on the table to deny claim number 7365. It's been seconded. Any other discussion? Okay, all those in favor of denying that claim, 7365, say aye. Opposed? Okay, so that claim is denied. In hopes that he will sign his W-9. Okay, also with Mr. Milo, this is claim number 7366. This has to do with his MP4 player. You all heard the situation, broomstick, top of the bed. Do we have a motion for that, or would you like to discuss first? Anybody? Okay, Senator Dietrich.
Yes, thank you, Madam Chair. I'm going to move that we approve claim number 7366 in the amount of $118.12, primarily because we had disparate views of the UTM, the unit team leader versus the deputy warden, and we know for a fact it was stolen. Did he leave it on top of his bed when he probably shouldn't have? Yes, but so that's why I would move to approve.
Representative Vaughn, seconds. Any more discussion? Okay, all those in favor of approving claim number 7366, say aye. Opposed? As a side note, after this is over, I would just say, I feel inclined to say that to the best of their ability, sometimes we still have consequences even when we're acting to the best of our ability. And I feel like this is, just kind of making that point. I know I do things to the best of my ability, and sometimes I still have consequences because of that. So just a point there.
Clarify.
Yes.
Madam Chair,
Mm-hmm.
I think I should just clarify that even though I think it's a given, we know that these dollars are to be paid out of agency funds. I just want to make that clear. I did not include that in my motion.
Everyone's okay with that? Yeah. Okay. All right. Thank you. Then that claim will be paid. All right. We're now moving on to claim number 7353, Ray Floyd Garcia Jr. We're making the call now.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, press 2 and listen to the prompt.
Please dial the extension number. Press the star key to start over. We will now connect you.
This is Ms. Mercer.
Good afternoon, ma'am. This is Merle with the Joint Committee on Special Claims Against the State of the Kansas Legislature. We're trying to reach a Mr. Ray Garcia. Is he available at your location?
He is here right now, and I will give them the phone.
Thank you.
Hello?
Hi, Mr. Garcia. This is Representative Humphreys. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7353 in the amount of $335.50 for property loss. You're on the speakerphone with the committee, and we've been provided with all of your documentation. In a minute, I'll give you the chance to tell the committee anything else that you would like us to know. After that, we'll hear from the department, their response, and then when that's completed, the committee will take some time to consider your claim, and then we'll get back to you within 21 days. Does that make sense?
Yeah, I hear you.
Okay, very good. So, Mr. Garcia, go ahead and tell us about your claim number 7353.
I've been locked up for a long time, and the only thing they're supposed to take 10% out of is money orders. It's never supposed to be any kind of government checks or any cashier's checks, just money orders. They're allowed to take 10% out. And when I was going through my banking and stuff, that's how I discovered that I was missing I had the stimulus checks sent to me from the IRS, and one was for like I think $1,400, and they took $140 out, and then the other one was I think I might believe it was $1,800 something, and they took 10% out of that. So that's what I'm claiming, is that they shouldn't have took that out, and they put that in my forced savings.
Okay, so Mr. Garcia, let me just stop you one quick second. The documentation we have seems to be for a different type of claim. This one was property loss for $335.50. I think we've heard
Oh, okay.
the one previously
All right.
about the bank statement.
Oh, yeah. All right, hold up. I don't have my paperwork. I picked the wrong paperwork up.
Okay, the one that we're looking at, it's you're claiming an unstated amount of property and legal transcripts were stolen from your cell. You remember that?
Transcripts, yep, that's right. Okay, my bad. Yep, that's my transcripts was stolen at the same time on that one property claim that you denied or dismissed on my last claim, and I had, when I got my property back, I had noticed my transcripts were missing, a set of them, and I had them out with my other property, and that's when I had to file another claim for the other lost property, and that was the transcripts, is how much they cost me, and I sent you the receipt, of a copy of the receipt I paid for them from the courts.
Okay, all right, we're going to hear now from the department. Mr. Bushbaum.
Thank you, Madam Chair. And just to clarify, the claim in which he's referring was 7348, and I get into that in my response. Mr. Garcia requests $335.50 for property loss. He claims an unstated amount of property and legal transcripts were stolen from his cell when the control officer allegedly left his door open. On July 17, 2023, Mr. Garcia filed a property loss claim in which he alleges an officer left his cell door open while he was at the infirmary for an unstated amount of time following an altercation with other residents. Corrections Counselor Reynolds reviewed the security footage and found that Mr. Garcia's cell was secured for the duration of his absence. The only time it was open was for his cellmate to step out, and it was promptly closed behind him. No residents entered his cell. The Secretary's designee reviewed the same footage and came to the same conclusion. For these reasons, the claim was denied. In the present claim, Mr. Garcia alleges the same facts and requests the same compensation as in his facility claim. He asserts that the corrections counselor lied in stating that video footage showed that his cell was locked while he was taken to the hospital. He has attached a unit team manager report from a previous legislative claim, 7348, in which it states that Mr. Garcia's cell door was indeed left open for residents to steal his property while he was in an altercation. The claims counselor's findings are not in conflict with the UTM's. Since Mr. Garcia has filed multiple facility and legislative claims for the same incident, the security footage reviewed for his claim was only for the time Mr. Garcia was at the hospital, the time period of this claim. The footage the UTM saw and wrote a report about was from earlier in the day during the altercation, not when he was at the hospital, when Mr. Garcia's cell door was left open. In his response to question 5, Mr. Garcia states that he has filed a lawsuit for property and personal injury on October 12, 2023 against the El Dorado Correctional Facility. Additionally, he states the amount will be for all property claims in this case. To clarify, Mr. Garcia has filed multiple property and personal injury claims, this one included, regarding the events of July 16, 2023. He was in an altercation with fellow residents which led him to being hit on the head with a log repeatedly, and his cell door was left open during the attack, allowing residents to steal his property. Since his lawsuit is for personal injury and property loss resulting from this incident, all property claims on this case includes the property of this claim. Since litigation has been filed by the claimant seeking compensation for the property loss alleged in his present claim, the department recommends that this claim be dismissed without prejudice pursuant to Rule 2. Thank you.
Okay, thank you. Committee, do you have any questions for either Mr. Bushbaum or Mr. Garcia? Representative Mon.
Mr. Garcia, my name is Carl Mon. I'm a state representative, but it's hard for me to research this stuff at the moment because the state judicial sites are down. But I just want to make sure, have I represented you on appeal in the past? Your name seems familiar to me.
What was that last part you said?
I said your name seems familiar to me, so I was just trying to make sure that I haven't represented you in the past. My name is Carl, last name Maughan, Maughan, and I think I may have represented you on appeal at some point, and I just wanted to verify whether you think that's true or not.
Did you represent me before?
Does his name?
That's what you're asking?
Yes, that's what he's asking. If his name is familiar to you and you think he represented you in some point previously.
On a property claim or something?
No, in your criminal case.
Oh, you might have. I don't remember. You might have.
Okay.
I'll probably.
What is his name again?
It's Carl Maughan, Maughan.
I think so.
Okay. All right. Then,
all right. Thank you. Yep.
You would like to recuse yourself?
Well, yeah, I mean, just as a.
Yeah.
It's probably better.
There could be conflict. Okay. Okay. Thank you. Any other questions, committee? Okay. Thank you, Mr. Garcia. We will take up this claim and discuss it and let you know our decision within 21 days. Okay.
I can't say anything else.
You can wrap it up quickly if you would like to.
Okay. On this claim, when the unit team, now I sent you also a copy of the claim that was on that same day. Now, the unit team manager, Hinkett, did the property claim saying he recommended for the property claim to be approved for $2,814. Now, the other unit team named Reynolds that did this property claim on the $335.50, when he claimed that he looked at the tape after the door was shut, and my cellie came out and he stood outside the door while it shutted. That's after everything was stolen. You see what I'm saying? And when I came back from the hospital, I went to the infirmary for 48 hours, and then the following Monday, I came back to the unit, and then I people were telling me that my stuff was stolen.
Mhm.
So I filed the property claim, and then when I got my property, that's what was missing, and I had noticed the scripts were missing. So
All right.
that's when I filed the other property claim a
Okay.
couple of days later.
Because I think
But
the crux of the issue here.
I just wanted you to know that the door was open when all my stuff was stolen with those transcripts.
Yep. So
You
here's
know what
my.
I'm saying?
Yeah, but here's the
I just
crux of the
I don't
issue is,
I don't want
Mr.
you to
Garcia,
misunderstand what
Mr. Garcia,
the property
Mr.
claim's
Garcia,
about.
you need to listen, okay? The crux of the issue here is that we understand that you filed a lawsuit for property and personal injury on October the 12th of this year, and that will play into our decision because we are the last resort. And so if you have a lawsuit pending, then that will inhibit us from being able to pay your claim. So that's going to be the crux of the issue. So we understand the door open, you know, what you're saying about the door open and everything, but we will be looking at if this is something that we can even take up, because if there's a pending lawsuit, that would play into that. Okay. So you understand that?
Yeah.
Okay. Thank you. All right. Committee, any other questions? All right. Thank you. We will let you know our decision within 21 days.
Okay.
All righty. Bye-bye. Since this is one that's quite straightforward, do we have a motion? Senator Dietrich.
Thank you, Madam Chair. I'll move to dismiss claim number 7353 without prejudice based on Rule 2.
Is there a second? Representative Vaughn seconds. Discussion? All those in favor say aye. Opposed? Okay, so this one will be, according to Rule 2, dismissed. Okay. All right, we're going to move on to claim number 7360, personal injury for $75,000.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen to the prompt. Please dial the extension number. Press the star key to start over. We will now connect you. You have reached the Lansing Correctional. Please dial the extension number. Press the star key to start over. We will now connect you. You have reached the Lansing Correction. Please dial the extension number. Press the star. We will now connect you. You have reached Unit Team Manager Susan Peebler, Manager.
So, Madam Chair, we tried calling this number earlier today, and there was we were able to reach We were able to reach correctional staff. However, they had to be pulled away. It sounded like there was an incident occurring at the facility. So we have now tried to call this number again, and it would appear that they are not available. So the committee, we could pick this up later this afternoon. We could continue to try contacting them, and so we could move on to the next claimant if you'd like.
Yeah, let's go ahead and do that. Just one second. Okay, so we'll go ahead and try to call claim number 7361. Property loss in the amount of $131.25.
To be cuffed up and removed from his cell and refused to attend.
Correct. So if I understand, you're saying he refused to attend the hearing?
Yes.
All right. Thank you, ma'am.
Thank you.
Have a good day.
So in this case, do we go ahead and look at the documentation and make a recommendation?
The committee can't do that, ma'am. We can read a quick summary of the claim. The committee can review the material, and we can ask the agency to respond, and you can make a determination off the written record, based on the written record.
I think we should go ahead and do that. So do you want to summarize or, okay, great.
This is claim 7361, Kedron Oliver versus the Kansas Department of Correction. Claimant states his MP4 player was on his bed at the El Dorado Correctional Facility when he was removed from the cell by staff, and upon returning to the cell, the player was gone.
Okay, Mr. Bushbaum, we'll like your response. You don't have to read the whole thing to us. If you could summarize, we would appreciate it.
Absolutely, Madam Chair.
Thank you.
So just very quickly, Mr. Oliver states in both of his facility claim and his present claim that he left his MP3 player on his blanket when it was taken by staff. He was notified days in advance that his bedding would be removed, and he watched for over 45 minutes as officers worked their way down to his cell, removing residents' bedding as they went. There was also a memo that was sent out, and it is attached as KDOC Attachment A, that says, weeks before the date of the incident, the facility notified by memo and bulletin that on April 26, 2023, the date of the incident that he alleges the MP3 player was lost, residents in restrictive housing would be receiving a new safety sleep system to replace their current sheets and blankets. And that's exactly what happened. On that date, officers went down the row of his cell block in restrictive housing and removed resident bedding as they went and replaced it with the new safer sleep system that the department has rolled out to prevent suicides and things like that. And his UTM added as well that Mr. Oliver's UTM stated that it was Mr. Oliver's responsibility to ensure that all items were off the bed during the transition. The two officers that removed his blankets from his cell did not identify an MP3 player or other personal items as they removed his bedding. Additionally, an entire search was done of laundry, which is where all the sheets were taken. No MP3 player has been found since in the facility laundry service. So the MP3 player has not been found. And he had weeks, he had days, and he had hours leading up to the incident to remove everything from his bedding. His UTM notified him to do so, and somehow his property was still on the bed at the time it was taken. And that's all.
And he asserts it was on his bed when it was taken.
Yes, Madam Chair.
Okay. And then my last question is, do we have receipts, or we know that he did have one?
He did have the MP3
Okay.
player that was confirmed at the facility.
Okay,
Yes, ma'am.
thank you. Do we have any questions for Mr. Bushbaum? Okay, committee, can we go ahead and make a motion on this one? Does anyone have any thoughts on that? Representative Mon?
Madam Chair, I'd move that we deny claim
7361.
361
Mhm.
on the basis of claimant didn't even care to come talk to us.
Is there a second? Okay, second, yes. Senator Haley.
I was hoping that we would, we get the representation from staff. He didn't come, he did not want to be restrained. I didn't get the clarity as to why he didn't.
As to why he didn't show up for this meeting, Senator?
You know, I'm just saying, you have your case comes up, you have a bad day, and you just don't want to go. And I understand it's one bite at the apple, but was there something that, as to why?
Nothing was communicated to the department as to why he would not want to be here for this hearing. Our understanding is that he was going to be here. There was no indication that he had any intention not to be.
And Madam Chair, I would, if that's a friendly amendment to my motion to make it dismissal without prejudice, I would accept that.
Second.
Thank you.
Okay, any more discussion on that? Okay, all those in favor of the motion, which is to dismiss claim number 7361 without prejudice, say aye. Opposed? Okay, that motion passes. All right, we have the claimant is attending in person. Okay, so we are now on claim number 7354. The claimant is attending in person, Mr. Martin Goodwin, property damages in the amount of $3,956.83. He stepped out for just a minute. But I think he'll be coming in shortly. And this is versus the Kansas Department of Wildlife and Parks. Okay, thank you. Well, we're up to date. We don't have any motion, so. I'd like to point out that Shirley has on a very festive blouse this morning. It's beautiful. I like it. Right. Thank you. It's really cute. I appreciate that. Okay, Mr. Goodwin, welcome.
Yes, Martin Goodwin.
Thank you for being here.
Put these on so I could hear better. My hearing aid has been acting up.
Okay.
Thank you.
Mm-hmm. So you've heard me introduce all these claims, so you kind of know what our system is going to be. First of all, we would like to hear from you about your claim. We have the documentation here on our computers. So please tell us what you'd like us to know about the claim.
Okay. I appreciate you taking the time to let me appear today. The October 28th, 2021, I was using a campsite at Clinton State Park. I woke up during the night and couldn't get back to sleep, and I went outside, sat in my lounge chair looking at the stars. Eventually got back in to go to sleep, got up after dawn, and there was a huge tree that fell down, crushed that chair that I was sitting in, and damaged my property. I got in my Jeep, 1997 Jeep, went up to the office, and ranger on duty was not interested in coming down. He said that the manager, Connor, would be in the next day and that I should speak with him about the issue. The next day came, I waited, no one showed up. About 1 o'clock, I took some photographs of the area, went up to the office to see the manager. This was during COVID, so you weren't allowed in the office actually, right? So the assistant manager come out and tried to get me to go away by telling me that it was my fault for using the campsite. And we went back and forth on that, and eventually Connor came out and he agreed to come down and take a look at the campsite. So I drove my Jeep down there. They drove behind me. He looked around the campsite and he agreed to give me a claim form and that I should drop it off at the office. That's all I was told. So I filled out the claim form. I spoke with body repair shop briefly, but I didn't get any estimates because I wasn't asked to get them. I dropped the claim form at the office on 12/8/21. The next day I went up to see Connor and asked him if he had seen that and was it in order, and he said that it was fine and that he would take it from there. I never heard back from anyone for months. Comes up to about April, I contacted Connor and asked him what was going on with my claim, and he said he'd get back to me. And he did call back about a week later and tell me it was illegal. That was it. A month after that, I contacted his regional supervisor via email, asked for an appointment to come in and discuss what was going on with my claim, and he never got back to me. At that point, I needed to research Mr. Dan Riley, the head counsel's phone number, call him directly, and leave a message, and then he did eventually get back to me. Now we're up in April, May 22, 7 months after. Mr. Riley said I needed to get estimates, and I was working on that, and these body shops are repair shops are very busy, and you had to make an appointment or wait for an appointment, and I was having a hard time getting all 3 estimates done. And Mr. Riley sent me an email that there would be a deadline of, I believe it was June 30th, to get my estimates to him. And I replied to him that I wasn't going to be able to do that in that time frame, and that after the state took 7 months to respond to this at all, I considered it exceptional that he was going to give me a few-week deadline to come up with the information he wanted. On 7/1, we got a letter from him saying that my claim was denied because I had not met the deadline. And based on the evidence collected by KDWP staff, Mr. Jim Clark is a friend of mine. I contacted him, got with him, and he was able to reach out to the district manager, Linda Lanterman, and get this thing reopened. At that point in time, we got Mr. Riley, the 3 estimates, statements from Mr. Clark, who was familiar with the vehicle, statements from the person I bought the vehicle from, and he sent me back a letter saying that he was only going to be able to he was not going to be able to pay the amount of the average of the estimates. Now, my original claim was for $1,850, but I was not aware of the high cost of all these repairs. So when we got the estimates, the average of those estimates went up to $3,900 and something, almost to $4,000, which is what we changed the claim to when we sent those estimates in. Mr. Riley gave reasons of pre-existing damage and other things. And we obtained more statements for him saying that those damages were not pre-existing from my mechanic, from the person I bought the car from, and from Mr. Clark. And we went back and forth on this thing for quite a while, and he was unwilling to negotiate anything, saying that the 1850 was more than adequate. I asked him why he had asked for the estimates. He wasn't going to pay attention to them, and you know, we really got nowhere. So after trying every way possible to get some negotiation, some accommodation done, I gave up and had to come here. Now, they're using as evidence this narrative on the incident report from Connor O'Flanagan, and there's a few things irregular here. There's no report date. The case number indicates something that happened on September 10th, 2021. The tree fell on the campsite October 28th, 2021. Mr. O'Flanagan says that he was there on the 29th at somewhere in the afternoon, 1400 hours, and that he noticed the tree was not touching the Jeep, and it was physically impossible for the tree to strike the Jeep and cause damage. Well, the Jeep wasn't parked where it was. I had used that Jeep for 2 days. He drove behind me, and while I drove that Jeep to the spot. Okay, so that's irregular. It also says that I should complete the claim and submit it to Pratt on this incident report. Well, if I was supposed to submit it to Pratt, I wonder why Connor O'Flanagan accepted it and didn't tell me to submit it to Pratt. It's another irregularity. Then he made a diagram of the place, and I have time-stamped pictures taken an hour before he says he was there that show that his diagram is completely wrong, completely false, and suits his narrative, not the actual facts. It's also interesting to see that he took plenty of pictures of the Jeep, but he didn't take any pictures of the campsite. And then he made a diagram up, which is not appropriate because it's not accurate. See what else we have here. It also says this is an internal email from Connor O'Flanagan to Dan Riley, April 26, 22. This is not in my packet I submitted. And it says, therefore, if a tree is falling down from above, there should be damage to the top of the Jeep. However, there is no damage to the top. Now I have here a picture that they took, and it shows the roof racks on my Jeep. I have 3 heavy-duty roof racks to transport my canoe. Now, when those limbs come down, they hit the roof rack and then they rain down on the side of that Jeep and put dents in all along it. I can let you have this if you like. Okay.
Okay.
It's also an internal email here, March 29th, 22, from Connor O'Flanagan to his regional supervisor, Jeff Bender. Attached is a claim against the state, Martin Goodwin, for an incident that occurred last October. Martin stated his Jeep was damaged, and he is stating his truck was damaged. Now, the truck damage was in the claim I submitted December 8th, 21. So it's not something I'm claiming now. Okay. And it says, while on the scene, it was physically impossible for the tree to have struck the Jeep. Now, Mr. Flanagan was on the scene 30 hours after. So he's against coming with this story. And this is March 29th. The claim was submitted December 28th, December 12th, 21. And it's only being forwarded out on March 29th, 22. I have this also here if you like, because I didn't put it in the packet.
Okay, so
I really
Mr.
wasn't
Goodwin,
sure
You
of
know, we do have a lot of the information.
Okay.
I think it would be good to hear from the department, and then maybe the committee will have some more questions for you. But
Thank you very much.
yeah, you've provided a lot, and the things that you provided will make copies. The extra things will make copies to get to the committee. You have copies? Okay. Okay. Yeah. Thank you. And so, yep. Mhm. Okay, and so committee, now we'll hear from the Department of Wildlife and Parks. And I'm sorry, I don't have your name. Dan Riley. Okay, if you, okay, would you wait and say that again in front of the microphone so people that are listening online can hear?
Yes, ma'am. I'm
Okay.
Dan Riley, Chief Counsel with the Department of Wildlife and Parks.
Okay, great. So tell us what you'd like us to know about this claim.
You bet. Mr. Goodwin's explanation of the chronological events is fairly reasonably close. And I know the committee is running behind, so I will try to be brief here. Basically, we have disputed facts in terms of the alleged damage. The story given by Mr. Goodwin has changed over time. When Connor Goodwin, and I would also like to tell the committee that Connor O'Flanagan, who is the officer that did the investigation, is present here today. So if the committee has any questions for him, he is available for that purpose. But as I say, the story from Mr. Goodwin has changed somewhat over time. If you note in the investigative report, he indicated the first conversation when Connor was there that the damage was confined to the left front quarter panel of the Jeep. And he made no mention of any damage to the pickup truck, which was also there. The tree struck a flatbed trailer, which was not damaged, and it struck his chair, which was pretty severely damaged because it was in the direct path of the tree. And Connor, when he did his investigation, along with the assistant park manager, Chris Orton, took quite a few pretty detailed pictures of the Jeep itself, since that's what Mr. Goodwin indicated the damage involved. And if you look at those photographs, they don't indicate that there's any damage there that would have been related to a tree fall, something coming from above and striking the vehicle. It's a 25-year-old Jeep, so it's got a lot of dents, and it's got a lot of rust, and it's got a lot of accumulated damage from over time. But in terms of anything that would relate to a tree falling, it's not supported by those photographs that were taken at that time. One of the things that was problematic in terms of the length of the time that Mr. Goodwin and I have been negotiating and discussing this matter is the fact that I did not have a photograph that indicated the positioning of the vehicles relative to the tree at the time it fell. However, in May of 2023, I received the photograph that Mr. Goodwin sent, which is marked as Wildlife and Parks Exhibit number 1 here. And that was the first real visual indication I had of the events and the location of everything at the time the tree fell. And if you notice by looking at Mr. Goodwin's own photograph here, the tree fell between the vehicles. It smashed the chair. You can see the smashed chair. You can see that it hit the flatbed trailer, but it missed the Jeep considerably and also the pickup truck. And like I say, if I'd seen this photograph initially in the conversation, I would have never offered to settle the case for the $1,850 that I offered him after approximately 12 months just to try to resolve the matter and move along. So basically what we have is a dispute in terms of the factual basis. And in terms of our necessary level of proof to settle a claim, we're subject to the rules of the Department of Administration. We can't authorize a claim or submit a claim for payment unless we do an investigation of the factual basis and make sure that the claim amount is reasonable based upon the facts. We have to certify that. They require signatures of both the Secretary of Wildlife and Parks and myself certifying that. And under this kind of factual basis, there's no way that that we can certify the damage because it's not supported by photographic evidence.
Okay, thank you.
Yes, ma'am.
Committee, do you have any questions for either Mr. Goodwin or the Department of Wildlife and Parks? Yes. Okay, so we'll start with Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Riley, for your testimony. I was wondering, for the settlement offer of $1,850, what was that based on? Was that just for the damage to the front left quarter? Why was that seen as a reasonable number? Or
that was based on his original claim of damage.
Okay.
And at that point, we had been hashing it out for months and months. And I mentioned in the front part of the information I filed, we get a lot of claims. We have 29 state parks, so claims of damage or something that are not infrequently handled by us. The average claim is resolved in a matter of days, weeks at the most. This one had already gone on for 12 months. And honestly, at that point, I was going to just try to make a settlement offer to move it along. And like I say, I had not seen the photograph that showed the entirety of the campsite. So I do not think I would have made that offer at all had I had that photograph at that time.
Follow-up.
As a follow-up, in the pictures, I was looking for any damage to the top of the car, and that's the hardest thing to be able to see in the photos. Was there any documentation of damage to the top?
Not that I've seen.
Okay.
Senator Haley, did you have a question?
Madam Chair, and thank you for your testimony. What is the standard of care that we have? I mean, I know that this is one that was marked for removal. You said that it was marked for removal. So is that evident? Is it maybe would a layperson or a camper in this case be able to see that it had been marked for removal, or was that internal, that the tree was?
I believe this tree actually was marked with spray paint. And we have never disputed, that the tree fell or that we were responsible for it. The only question that's been presented here is in terms of what damage, if any, occurred. So yeah, we haven't made any claim of we're not responsible for the tree. So
let me understand. So we do extend that to anybody? I mean, does this happen on an ongoing basis? Are you aware of any other time that because of falling trees that we have subrogated loss to someone lawfully on our campsites?
Well, typically, Senator, if damage occurs to someone while they're in a state park, and it's reasonably and factually represented, so that we know that what is alleged actually took place, we don't hesitate to settle that claim and pay for the damage. We have damages that result from lawnmowers that throw rocks or trees that fall, or that, because we consider ourselves hosts. And Mr. Goodwin was our guest at the time the tree fell. And as such, we do not try to belabor the issue when it comes to resolving complaints. That being said, we also have to be able to verify the factual basis, because we can't pay claims if we don't see the factual evidence. So
Understand. Thank you. Thank you, Madam Chair.
Representative Mon.
Thank you, Madam Chair. I thought you had indicated that the tree fell between the Jeep and the truck, right?
If you look at the photograph, and do you have our information there?
I do.
Our Exhibit 1 is the only photographic indication I've ever seen of that particular area, and it, in my opinion, shows that the tree fell between the two vehicles.
So my question is, when a tree falls, it's not simply going to be, unless it falls on top of the vehicle. There's going to be residual damage as far as branches flying out, or when a tree falls down, I would think that there would be branches that'd be broken off and flung around. And so my question was simply, is there any cause in your mind that would have, the residual damage from when the tree falls, and maybe logs or branches break off and go flying in all directions that could have caused some of the damage to the Jeep.
Well, actually, I looked for indications of that, and in terms of documented evidence, the best indication that I have that relates to that are the 10 or 11 pictures that were taken the day of the investigation of the Jeep itself. And I didn't see anything there that appeared to have been related to a tree falling or scratches by limbs or anything else. One other incidental piece of information is the tree that fell was a black locust. And black locusts are notoriously brittle, especially when they get to the stage where they've rotted enough so they fall down. And it's entirely possible, based on that characteristic, that there wasn't enough integrity left in the top of that tree to damage anything. For example, the photograph shows that it landed on the flatbed trailer, didn't do any damage to the trailer. So.
Madam Chair, I do have a question for Mr. Goodwin. That's
Go ahead, Mr. Goodwin.
Mr. Goodwin, my question for you is whether or not the vehicle was insured and whether you submitted an insurance claim.
There was no insurance claim from me to my insurance company at all.
Okay, but it was insured?
It's not insured for that type of thing. No physical damage, no physical damage insurance.
Okay. Can you explain that to me? I think that's what insurance is. Was it just third-party insurance? So if you damage somebody else, is that?
Exactly. There's no fault insurance if someone hits you. There's liability insurance that you have to carry. And then there's additional damage from other things, which I did not have that on the policy.
Okay. Have you, are there any ongoing lawsuits at the moment other than the claim against the state?
No lawsuits, no.
Okay. All right. Thank you. Well, just a follow-up. Why not? Why have you not filed a lawsuit against the state rather coming to us at this point?
To sue them for this damage to the vehicle is $10,000 in legal fees. The damage to the vehicle is $4,000. So I'd rather not pay $6,000 to get nowhere.
Sure, you could have gone to a small claims court.
I don't believe you could take small claims court against the state, plus the damage amount is over the limit.
Okay.
It's my understanding.
And
I was just hoping that I would be treated fairly. I mean, Mr. Riley makes a lot of statements, but he has no evidence. He says this, he says that, you know, it fell between the limbs that are in the pictures, hit the side of the Jeep and bounced onto the ground. Yeah. It's very simple.
I appreciate it. Thank you, Mr. Goodwin.
Thank you, sir.
Mr. Goodwin, so did you take this picture?
I took that.
And when did you take this picture?
An hour before Connor came over there on the 29th at 1 o'clock.
And you had moved your Jeep at this point?
I drove it for 2 days.
And where was your Jeep parked?
Right next to the trailer.
Right next to the trailer, I see. Okay, and where was you had a tent, you said?
There was what?
Your tent. Did you have a tent?
Camper. Looking at that photo is to the right.
Okay.
Camper was not affected.
Okay, so I see part of the tree kind of from this angle to the left of the trailer, and that's what you're saying hit your Jeep. Okay.
And the pickup was to the right of the trailer, and the chair was before them. I have a photograph of the limbs laying right next to the cab of the pickup, where they're saying the limbs didn't hit the pickup. I have a photograph right there in my file of that. It's not in your file. I didn't want to burden the committee with so much information, so I tried to slim it down.
And so you say that the windshield on the truck was broken, and I can see a branch kind of bent over that way, but so that's probably from that.
Windshield was cracked on the pickup.
And had you moved the truck, or the truck is in the same position as it was when
the truck was not moved when that picture was taken? The Jeep had been moved.
Okay, all right, thank you.
I had to get up to the office about this incident, so I drove my Jeep there. I was taken aback. I mean, that chair was crushed, and I was sitting in that chair a few hours before. It kind of take you aback that I could have been sitting there when this thing fell.
Yes.
I have photographs of the
I'd
base
say-
of that tree. There's no root system. It just simply fell over. And this is a tree this round that was left up between 3 campsites. And then the person who's responsible for that not to happen is the person saying that it didn't happen.
And I'm just going to say I'm thankful that you weren't still sitting in the chair. And I think someone has a plan for you. So there you go.
I mean, I was asked for 3 estimates. Mr. Riley's saying it's 1850. He didn't give me any estimates. He's just coming up with a number, 1850.
We understand that. Let me see if the committee has any more questions. Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Goodwin. So I just wanted to understand the current claim that you have. Is it claiming damage to that one side of the car, or is it claiming damage to multiple sides of the Jeep?
The claim right now with the appeal was based on 3 estimates for the repair to the Jeep, the damage to the windshield on the Ford pickup, and the cost of the chair. I don't know if that answers your question.
So is the estimate for the damage to the Jeep for all sides of the Jeep?
No, just what was there. It says it right in there. And I provided statements saying that the Briggs estimate has photographs of the Jeep, and he has a wand pointing to the damaged parts. I have 2 statements in there that were notarized, one from Mr. Jim Clark and another one from Richard Smith, who's a retired police officer. And both those statements say that they're familiar with that vehicle and that damage was not there prior to this incident happening.
Okay.
So the damage is just for that side of the Jeep. Things are expensive. It's more than I thought.
Senator Dietrich has a question now.
Hi, Mr. Goodwin. Do you still have your pickup?
No, the pickup's gone.
Okay, and are you still driving your Jeep?
Yes, ma'am.
Okay, thank you.
Representative Vaughn, sorry.
We get that a lot. Thank you, Madam Chair. So what's the cost of the chair that was destroyed?
Trailer?
The chair.
Chair, I think it was $70. It's in the information I provided.
And, you know, we get a lot of information.
We had 3 estimates. One was low 3,000, one was upper 3,000, and one was 4,800 for the repair to the Jeep. We averaged those 3 plus the 2 repairs for the windshield and the cost of the chair, and that's where we came up with the number that we submitted to Mr. Riley in August of 22.
Okay. Thank you, sir.
Okay, committee, do you have any other questions? Representative Rajas.
Thanks for being here. Sorry you had to endure this morning, but we still have hours.
Thank you for letting me be here.
So are you going to get the Jeep fixed?
I'm not sure.
Still camping?
The value of the Jeep is less than it should be if I don't fix it and sell it. Sure. So I may fix it myself.
I'm sorry it took so long, but I mean, would you entertain settlement offer or something so you can move on and the state can move on?
I've tried that and I couldn't get anywhere.
Well, now you're at the point where
yes, I would.
It's the point of last resort.
Absolutely.
So, I mean, I don't want you to keep to not move on. And same thing with the state. I'm not sure exactly why this has taken so long or whatever, but that's what I'm just trying to figure out. And I understand, where a tree like that could splinter a lot of things. So I get that. So that was my question, though, if you're going to get it fixed, because it would seem to me that a Jeep that old, I have a 20-year-old pickup, and if I was to put $3,500 in it, well, the price of pickups today might be a little different, but but understand and know, especially where I'm from, Western Kansas, it's probably a little bit different than Eastern Kansas. Maybe just a slight bit, but yeah, the business of auto repair and is very expensive for because of whatever. But anyway, okay. Well, that was my curiosity of and since that day, you've been using this vehicle as basically on a daily basis, correct?
Drivable, there did not affect its drivability.
Okay. Okay.
There are dents all along the driver's side where the limbs hit it.
Thank you, Madam Chair.
Thank you. Okay, committee, are there any other questions? Okay, thank you for coming, both of you. We really appreciate you coming to the committee. The committee will discuss the matter, and you're welcome to stay, or we will let you know within 21 days what our decision is.
Okay.
Thank you.
Thank you all.
Thank you both for being here, and everybody. Okay, committee, I think we need to go ahead and make a decision about this one. It's the last thing on our docket, and then we will have lunch. And so do we have a motion? Do we have, or you want to discuss it first? What are people thinking? I'll start. I think it's interesting that it took so long, but I do think it's clear there's documentation all along the way. So I think just the fact that it took so long is not necessarily determinative one way or the other. So I'm kind of letting that go because there's documentation. We'll get back to you. Okay, you go get her estimate. Okay, you know, both sides it seems like. So okay, Senator Dietrich.
Thank you, Madam Chair. This really is kind of a tough one though, because it's, you know, a lot of information, a lot of points here. I think the original offer though of the $1,850 is probably something that we could consider. I mean, it's really a ton of information. These are older vehicles. The tree clearly fell. And, you know, we're having to look at documentation, and that was an original offer. I guess I'm thinking I'm comfortable with that, but I'm just putting that out there for discussion.
Okay, anyone else? Representative Vaughn? Mon? I'm so sorry. It's I need lunch.
I'm not sure, and you know, Madam Chair, you're an attorney as well, so but I'm not sure that it's correct that you can't take the state to small claims court if advisors weigh in on that, because I think there is a possibility of a claim here. This was 2 years ago. I think there is a possibility that the claim can still be made in court. So I'm questioning whether we're really at the last
Okay,
stage.
why don't you look it up? So while they're looking it up, I'm thinking, I thought that the limit for small claims was higher than this, so I think it could be taken to small claims, but I do, I would somewhat agree with the analysis that hiring an attorney to take it to small claims would maybe do, you know, dismiss any. Oh yeah, that's right. It's 4,000 is what the, okay, limit is. Okay, we know. That's okay. That would be something to know. Nick, if you could know if it's the state is someone that you can. Okay, any other discussion? Senator Haley.
I thank you, Madam Chair. I'd like to kind of dispose of this myself. I mean, if you has a supplemental, I mean, I've been here a long time. First time I learned that the state bears liability for our parks to the extent that we do. That, you know, it's not, and at your own risk situation, especially for acts of nature, like a falling tree. If we knocked over the tree somehow with some equipment, I'd understand. But in that it has been, by the testimony of our department counsel, of KDWP's counsel, that we do bear that, and I would go with this. I don't want to open up the floodgates of what could be ongoing, filings for this. I don't think that it was well documented that indeed we are responsible, but time being of the essence, I would support it. The motion is made by Senator Dietrich or anyone, the first restitution of 1,800, in that he doesn't have the supplemental insurance. I've got an old vehicle too, full disclosure, and I only have the minimum required by law in terms of insurance for replacement. So if that motion is made, I would support that. And if he still feels like he has some supplemental need, he can then file with small claims and carry that case then, if they are.
Determined that you cannot sue the state in small claims. It seems like that's, would you agree? We trust Google. Yeah, Senator Dietrich.
So I fully recognize that Dan Riley, right? After he had investigated this more thoroughly, felt that maybe we shouldn't even as a state offer the $1,850. But I do believe because this has gone on so long, he can't sue the state in small claims court. He's got minimal insurance, older vehicle. I can go either way on this, but I always want to try and be fair and to put myself in his place. And I'm sure it was a very traumatic experience when the tree fell. And you're right, Senator Haley, we do not want to open up the floodgates, for claims. So I'm very torn on this, but I'm wanting to be fair and just. So,
Representative Rajas.
So, just so I understand, the $1,800 whatever, give or take, was just kind of a pie in the sky based on whatever. And Mr. Goodwin, his extra costs, there's no other legal fees in this, correct? So okay. Well, Madam Chair, I would move that that the state pay Mr. Goodwin the sum of $2,000 for damage to the chair and the vehicle for claim number 7354.
You have a second? Second by Representative Mon. Okay, any other discussion? I would like to point out, I'm not that pleased that the state was using that photograph as evidence. It clearly wasn't taken right after the accident. And so I find that I was disappointed to hear that that's what they were basing it on, that, oh, and now we wouldn't even offer the 1,800 based on that photo. But we heard that photo again, accepting the word, but I find it kind of, I wasn't happy that they were basing their part of their response on that photograph when it seems like it was the Jeep had been moved. I'm just feeling like I needed to mention that. You may. Mm-hmm.
The reason I indicated that time frame is because,
yeah.
Sorry, Dan Riley, Chief Counsel.
Thank you.
The reason I indicated that time frame is because that's what Mr. Goodwin indicated to me. That photograph came from him, not from us.
Right, I understand that.
He told me it was taken the day that the tree fell.
Okay.
So I didn't misrepresent it. I just conveyed what he represented to me.
I appreciate knowing that.
Because that, like I say, that was not a photograph that Connor or.
No, we understood that he took that. So that was understandable. But I appreciate that clarification.
No,
thank you.
Thank you.
Thanks, that's helpful. Merle.
Madam Chair, if I could just clarify one item on the motion for the maker of motion. That's $2,000 paid from existing resources, correct? Is that correct?
Yes. Yes.
rather than an additional appropriation from the state general fund for $2,000.
And the second understands that. Yes. Okay. All right. Any other discussion? Okay. All those in favor of the motion of paying $2,000 for claim number 7354, say aye. Opposed? Okay. Then that is what we will do. Okay. Committee, lunch, late. We're due back at 1:35. Clearly, we're not going to do that. I will say we do have a little bit of wiggle room at the end of the day, possibly. And so why don't we say we'll come, it's 1:15. Let's say we'll come back at 2:15. So you have 1 hour. Okay, thank you. We are recessed. Yes, Representative.
Well, okay, that's fine, and I appreciate that, but we probably need to let the other ones know, because maybe like the one that didn't want to do this morning, it was already in the noon hour, maybe he wanted to eat, and so now all of a sudden, if these ones that are left are 45 minutes behind, I mean, what, I mean, I guess that's what I'm curious about.
I appreciate that,
So-
Representative. So, Merle, would you be able to let them know that we're running late, or are you suggesting we just speed it up and take a much shorter lunch break? What would you like?
It's at the discretion of the chair. If it was up to me, I would say we take a 10-minute pause and keep rolling, but that's not my call, Madam Chair.
Some committees have people provide lunch, but this would not be one of those committees.
That's Wildlife Park's left, so no.
Well, we probably didn't.
It looks like everyone else is in KDOC, and my experience has generally been that they can be called up pretty quickly. So.
Yep. And just to note, if you all, the last 3 claims are Mr. Simmons, who has had a malfunction with his hearing aid. In previous times, we let him know this is kind of his last chance. But so we're not, I mean, I don't know if we've confirmed the appointment with him today, or if we know what he's planning on doing.
We have not heard yet from Mr. Simmons. We will let the afternoon claimants know that they're being rescheduled. Everything is sort of shifting back. Whatever, we'll give them a heads up that their scheduled hearing is shifting. Just need to make sure we know which time to let them be available.
I'm gonna be judicious and say let's come back at 2. So we're gonna come back at 2. We're gonna have a little bit shorter lunch, and then we'll get on it, and we won't be so late for those folks. Okay, see you all at 2. Okay, we're going to go ahead and call the committee meeting back to order. We do have a quorum, so we're going to go ahead and start with the first thing we have is to approve the minutes from October 25th, 2023. Do we have a motion to approve the minutes?
So moved.
Second.
Moved and seconded to approve the minutes. Are there any additions or corrections? Okay, all in favor of approving the minutes, say aye. Opposed? Okay, minutes are approved. We will move now to claim number 7364, personal injury claim of $1.5 million. And get them on the phone.
Thank you. Good afternoon. My name is Mike Ditch, and I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Michael Lindberg. Is he available?
Yes, 1 second. Hello?
Yes, Mr. Lindberg. This is Susan Humphreys, and I'm the chair of the Joint Committee on Special Claims Against the State at the Kansas Legislature. The committee is hearing your claim number 7364 right now. It's a personal injury claim for $1.5 million. You're on the speakerphone with the committee right now in the State House here. And we have all of your documentation that you provided. In just a minute, I'll ask you to tell us anything else. And then when you're finished, we will ask a representative from the agency to tell us their side of the issue. And then when that is all complete, we'll consider your matter. We'll take some time and give you a written notification within 21 days. Does that make sense to you?
Yeah, the only problem I have, though, is you combined one of my claims. I sent in 3, and you combined the 1.5 and the 600,000 into one, and they were not supposed to. There's 2 different claims on that. This one was. Go ahead.
We do have a personal injury claim for 1.5 million, and we also have a separate personal injury claim for 600,000.
Yeah, and then there should be one for another one for one was for my toe getting infected and I'm losing the toe. And then the other one was I was supposed to have my toe sent back to me after it was removed for religious and cultural reasons, and the facility lost it, and that's the 1.5.
Okay, so there's 2 separate claims. You're not saying there's a third claim?
There's 3 claims. One was for eyes, one was for my losing my toe getting infected and getting it cut off, and then the other one was for the facility losing my toe when it was supposed to be sent back to me.
Okay, all right. So I'm going to ask the representative of the of the research department to comment. Earl?
Yes, ma'am. The the claimant submitted 2 claims. One claim was for $1.5 million, which involves a stub toe that became infected. The second claim, claim 7363, is for $600,000 for what he stated was inadequate optometry care. Those were the only 2 claims submitted by the claimant. You'll see the cover document is in his words and in his language. There's not a third claim under consideration.
I know. I sent in 3 claims, and then on the third one, you combined it to the 1.5. That's what I was wanting to know what happened. I sent a letter off to you, and I don't know what happened to it. Nothing, never heard anything back.
Okay. Do we get a letter? Just like, would you have sent it in the last couple days?
No,
we've not.
Let's see.
Madam Chair, we've not received a letter from the claimant. You can see the claims submitted by him are written in his own hand. One is 1.5 million.
Okay, I think we'll take up that one first.
Okay.
Unless, just 1 second.
I am incorrect. There is two claims from him,
Right.
and one is for 500,000 and one is for 600,000. So there is
Right,
not.
And then there should be one for, and then there was a third one for 1.5.
We're looking, just a
Because
minute,
the-
Mr. Lindberg.
Yeah, because the paper said the 1.5 was corrected, and I was like, no, that's not supposed to be corrected, and that's when I sent it off. And I sent that off like 3 days after I gave notice. I got the paper notice that the date was supposed to be today.
So, Madam Chair, the only claims that we currently have from this gentleman right now is claim 7363 for 600,000, and claim 7364 for 1.5. So I'm not aware of the third claim that he's referencing.
Okay. Okay, so Mr. Lindberg, what we would like to do is we'll take these two that we have right now,
Okay.
and then we maybe it will become a little more clear. But we're going to go ahead and start with 7364, which is a 1.5 million. And why don't you tell us about that claim? Anything extra that you'd like us to know?
Well, the claim that was filed under was for after the surgery was done. I had requested my toe to be sent back to me after the pathology group was done with it, to be either sent out or to be taken care of for religious, cultural reasons, because my religion and culture also says I can't be buried as a whole person. I have to have the whole body there, and so mutilation of a body part must be contained or kept with the person to be buried. The facility, the pathology group, RPS or something out of Kansas City, sent a letter to me, or I've got a hold of someone on the outside. My parents got a hold of them, and they said they have sent it to the facility. The facility at this point says they never received it, or if they did, they don't know where it's at. And I don't know where my toe's at. I want my toe back for cultural and religious reasons, and it's been lost.
Okay, all right. So we may have some clarification here.
I just want to clarify again, ma'am. He's submitted one claim. He's talking about a claim for which you do not have the claim document for. It has not been submitted. So there is one claim, 7364 for 1.5 million, that involves essentially the injury of the toe.
Mm-hmm.
And then there is a second claim of 7363 600,000.
Okay, so Mr. Lindberg, I will say we are looking at the documentation, and we have a form that you filled out, and then I think staff added the claim number 7364.
Well, I got.
And as we read
I don't
through
have the.
it, that particular claim is about the fact that you lost your toe and you've loss of job. So why don't we talk about that one first?
Okay. All right.
Can you tell us about that?
That one. Oh, okay. I was a tablet porter here at this facility, and well, first of all, the facility early of the year passed things stating that all Crocs were to be taken from inmates at this facility. I'm diabetic. I'm not supposed to have open-toed shoes or anything like that for to wear. And upon exiting a shower, wearing a open-toed shower shoe, I smacked my toe on a 5-inch concrete barrier that they have separating the shower from the main dorm area to keep the water out. Unbeknownst to me, due to diabetic neuropathy, I had fractured my toe and broke it because I had no feelings in my toe. I did not notice it and went about the day after putting on my sock and everything. Later that night, I had noticed that there was blood on my sock. Apparently, I pulled off the sock and looked at it. My toe had swollen up, and it was bleeding around the edges of the toenail. I notified the guards. The clinic testified or said that since it was Friday night, to put in a sick call on Monday and to come in and look at it was not life-threatening. I told them I was diabetic. They needed to look at it immediately. I put in a sick call on Monday to go look at the toe. They said, oh, it's broken. There's not much we can do about it. And I said, well, can you get an x-ray? And they said, well, there's nothing we would be able to do about the toe. It's just broken, which then a couple days later started getting red and swelling up. I went in on that Friday. They said, oh, it looks like it's infected. They gave me some antibiotics. They put me on pill antibiotics for like 7 days. It kind of went down a little bit. After I was off of it, it got red again. Basically, a month later, I got an x-ray. I got an injection of shot and something else. That's when they noticed that there was osteomyelitis set into the toe fracture. I was put on a 8-week IV regimen. I think it was 8 or 12-week regimen of IV solution and put in the clinic, which then because I was moved into the clinic, I lost my job of a tablet porter, which was giving me $30 a month. And because the IVs did not cure the infection, I had to have my toe removed. And being removed from the toe, then I was put on feed-in, still not able to collect the month tablet porter, and still am on feed-in. And because of and I'm not allowed to have Crocs, wear Crocs, or use Crocs, which as a diabetic, I think should be allowed through either the medical clinic providing them or the facility providing them to at least the diabetics, so that this does not happen again. And because wearing the thong shower shoes that are issued by the state, and the other ones that just go over the open toes like a sandal part, it's hard to keep it on. It is more. I've almost slipped a couple times in the shower because they do slip off that way. So what I'm asking is for either the facility to allow medical people who have deformations of the feet through diabetics to have a foot so we don't smack it on the showers when we get out. Monetary compensation.
Yep. Okay. So I think we understand that. We're going to hear from the agency now. Thank you, Mr. Lindberg.
Thank you, Madam Chair. I'll make my remarks brief as I know we're running a bit behind schedule. KAR 44-16-104A and IMPP 01118 state that residents must submit claims of personal injury to the facility and Secretary of Corrections within 10 calendar days of the claimed personal injury. Mr. Lindberg never filed a personal injury claim for this issue. He has not exhausted his administrative remedies regarding the claim, and therefore it should be dismissed according to the committee's Rule 2. Additionally, Rule 2 of the committee provides that claimant should first exhaust judicial remedies as well. Mr. Lindberg has not exhausted these. His claim represents a situation where application of the rule would be equitable and reasonable considering the amount that he seeks, and it also includes issues of a medical nature. The legislative claims process is, of course, intended as a place of last resort, and that's clearly not the status of Mr. Lindberg's present claim. Thank you.
Committee, do you have any questions for either Mr. Lindberg, Mr. Lindberg, or Mr. Bushbaum? Representative Mon.
This is for Mr. Lindberg. Sir, have you filed a lawsuit regarding this matter?
No, I haven't. I was told the exact opposite, that this was the way to go before I file a lawsuit to prevent a lawsuit from being done, to see if I could get a medical claim first. And if not, I did not know that, and I will refile again, and I'll file a lawsuit instead, if that's the way it's supposed to do. I thought it was supposed to be the other way around.
Okay. Oh, sorry. Go ahead. Okay. Yep. So we're sort of the last resort. And so we will take that into consideration, and we will take time and discuss this issue and then let you know what we decided on it. But let's move on to your claim number 7363, which is the $600,000 claim. What would you like to tell us about that one?
Basically, it's the same thing on that one, too. I have not filed a judicial lawsuit on that one. I thought, again, that this was the way to go during the procedure to get remedies of suit for it. That's the way I was told, so I'm sorry if I got this out of order and filed a judicial civil lawsuit instead.
Okay.
Unless you want to hear what happened.
No, we can read about it because we do have your documentation here in front of us, but we'll probably just take it as that. But I am curious, like, who did you get that information from?
Well, I was asking people up here. I asked, let's see, the medical people, the clinic. I asked someone in the clinic how, and then I was asking some of the people in the library up here, and I can't remember if I asked the unit team or not up here or not about it, but they said if I had a problem with that, to file a medical claim or file a claim against the state about it, and I don't think we even discussed about have I done all the final the seeking remedies through the paperwork and everything.
Okay. Okay, yeah, that, we're really sort of the last resort. So we will hear now from the agency about this particular claim. I assume it's similar, but go ahead, Mr. Bushbaum.
Thank you, Madam Chair. The department's arguments are substantively the same as the prior argument and has not exhausted. He didn't file a personal injury claim since 2017 for this issue, since he had surgery in 2017 that propagated all of his issues that he's claiming. And he also has not filed a lawsuit.
Okay, thank you. Committee, do you have any questions? Yes. We'll hear from Revisor Heim.
If the injury occurred in 2017, I think the statute of limitations is long gone. So this may be the appropriate place for hearing this claim. Typically, you don't come here first unless it's an implied contract kind of a claim, which we've reviewed before, but this is not a contract claim. But if the injury was in 2017, he doesn't have a ability to file a lawsuit at this time that I'm aware of. Negligence is 2-3 years. I can't remember. 2, I think.
Just from what I understand, the first claim was on February 14th of 2023, the tow. And then are you saying the second claim for the 600,000? I didn't see a date on that one. That one is the...
Yeah, these are materially different claims.
Okay.
The second one, the one we're on right now, is an optometry claim in which he had laser eye surgery in 2017.
Okay.
That has led to issues now.
Okay. Okay, we'll take that into consideration. Thank you for that clarification. I appreciate that, both of you. Okay. All right, then, Mr. Lindberg, as far as your third claim, it looks like to me we didn't, somehow, I don't know what happened exactly, but if you do have a separate claim, you'll need to go ahead and file that other claim if you do have a third one. And then the first and second one we will talk about as a committee. We'll spend some time discussing it, and we'll let you know our decision within 21 days, and you'll get written notification.
Well, can I state something about the optometry one? Hello?
Yes, you may.
Okay. The reason why I waited so long for it is because I kept doing checkups and stuff, and they were doing updates. I wanted to make sure that I had the full effect of what was damage done at that time to see if it was going to be able to be healed up fully, and if it had stopped, or if I was going to have to continue getting more laser surgery on it done. And that had just finally been released from that, and that's why I filed at this point.
Okay, thank you. So it's maybe a little bit unclear when the injury actually occurred. Or are you saying if it occurred?
But I came to this facility in 2014, and I let the clinic here know about my problems with the eyes I was having. And 2 years they kept pushing me off and delaying it. And then finally I got angry at him and kind of exploded and told the eye doctor, and he said, "Who told you, you didn't have problems?" And I said, "One nurse did, and he hadn't received information." And then he goes, "You need to see a specialist." Specialist said, "You need surgery right now, otherwise you're going to go blind." And then that's where I've been at for the last 5 years, doing checkups roughly every 6 months. And then just recently he released me. And then it was like, okay. And then so I wanted to get all the paperwork and file, and I haven't been able to get the paperwork here to file it and everything, but that's why I put the claim in. So I figure I have to do a judicial thing first.
Okay. All right. That's helpful.
Yep.
Thank you. Okay. Committee, yes. Representative Mon has a question.
Mr. Lindberg, I'm curious as to the state of your eyesight right now. Are you able to see and read, and where are we with that?
My left eye, I have a blind spot from the damage that was done. It's just a black spot right in the center of my eye, and the vision in the left eye has just gone down. I mean, like as what the doctor said, is I've lost 10% of the eyesight in that eye. The damage is irreparable from even though I got the corrective laser surgery.
Thank you.
Okay, thank you. All right. Thank you, Mr. Lindberg. We'll let you know within 21 days what our decision is.
Okay. Thank you.
Thank you. Bye-bye.
Bye.
Okay, committee, let's go ahead and just talk about these two and get that done. As you heard, especially the first one, it seems like he's not looked at all the remedies that he has available to him. So let's talk about that one. 7364 personal injury. Do we have a motion?
Madam Chair, I'd be happy to make a motion. I think we should probably dismiss this claim without prejudice I was going to say Rule 2, but we also have Rule 5, but I think per Rule 2 would apply to this.
And would you, Mike, could you tell us what Rule 5 says?
A claim for an award for personal injuries to an inmate of a correctional institution shall be determined in accordance with the provisions of the Workers' Compensation Act. So the Workers' Compensation Act it's a percentage, I believe, of the average weekly wage. It's not very much. And times the number of weeks, I can get the statute out. I was looking for it right now. But the bottom line is it's going to be significantly less than what he's asked for. So.
Okay. All right. Thank you for that. Okay. Did we have a second to that motion? Representative Vaughn. Any more discussion?
Could I clarify, this is a Rule 2 motion?
Mine is a Rule 2 motion. That was just a piece of information that would be beneficial, yeah.
Okay, all those in favor of dismissing without prejudice claim 7364, say aye.
Aye.
Opposed? Okay, so that one will be dismissed without prejudice. All right, claim number 7363. Personal injury. It had to do with eyesight. Yep.
So, Madam Chair, even though it's been 6 years, I think that there have things that he probably could have done along the way and still has the opportunity to do. So I'm going to again make the motion that we dismiss claim number 7363 without prejudice per Rule 2.
Your second. Okay. Representative Vaughn.
Thank you, Madam Chair. And this might be for revisers, but because we are kind of going back and forth on whether or not this would be eligible under the statute of limitations, what are the other available remedies? Do we know? Would it be at a facility level? Would it be a grievance? Do we know?
The eyesight, which I said earlier, the statute of limitations for a lawsuit is long gone. So I don't know what remedy, if anything, at the facility level. I'm guessing there's nothing, since he didn't comply with the timely fashion of reporting a personal injury for this regard. So this committee, and for the eyesight thing, is probably the end of it. But you know, if you
Mr. Bushbaum, did you have a comment?
Thank you, Madam Chair. Yeah, just briefly. Since the surgery occurred in 2017, he had multiple follow-ups. I read through his complete medical record. Took a while. And he received medical care not so much from the facility itself or KDOC. This was a private party, a private medical provider that did the laser eye surgery. So if there are issues relating to that surgery, he should probably have sought remedy from that medical provider. The department did not partially blind him. This was a result of the surgery he got from a private entity.
Okay, thank you. That's helpful. And then, but I thought I heard it was indicated maybe he needed a corrective surgery. Did we know if he received that?
He received multiple surgeries. I detailed them in my facility response. It's in the second paragraph under the legislative claim title. He did receive in March 13th and March 24th surgeries after the initial laser eye surgery for corrective purposes. And so he received consistent support after that, not only from our medical staff to make sure that he had eye patches and was receiving, pain medications, but also the private healthcare provider that did the surgery followed up with him consistently thereafter for several years.
Thank you. Okay, I don't think, yes, Senator.
Madam Chair, I am willing to withdraw that motion because it appears there are no other remedies that he can access. Is that correct? Is that what I'm hearing?
I believe so.
So
yes, Senator.
I would like to make another motion, Madam Chair.
Yes.
If I may, I will just move that the committee deny claim number 7363 in the amount of $600,000.
We have a second. Representative Rogers seconds. Representative Mon, did you have a question?
I do. Thank you, Madam Chair. So when you say that the injury was caused by a third-party provider, this third-party provider is contracted through the facility, or how does that work?
Yes, Representative. I am unsure if we have a contract with them. However, they were the closest specialist to the facility itself. So they may have, unless I'm mistaken, they may have sought care there first. I don't know if there's a contract that exists between the two parties at this time.
But either way, that's who the facility provided for the claimant. I mean, he's not at liberty to just go find his own eye doctor, right? I mean, somebody's the facility and the agency has to actually approve that and provide that, and so they kind of like an agent of the facility to some degree.
Correct, Representative. The physician that was involved with this, the optometrist at the facility under Centurion, made the recommendation to the facility that was the third party for the specialized treatments.
Thank you.
Representative Vaughn.
Thank you, Madam Chair. So I'm reading through your testimony, but I wanted to clarify. So he received the laser eye surgery, and then he's claiming through follow-up appointments after the surgery that the adequate concern was not raised about the state of his eyes, and that has led to the current deterioration of his vision. Is that correct, or was it before his surgery?
So the first medical record that I had found of him complaining of any issues with his eyesight, seeing double vision, was in 2016. And then he was promptly seen by the optometrist in 2016, I think 2 weeks later. And he was then sent in January of 2017, soon after, to see the specialist third party. So the double vision was there. The 30% vision loss, which he claims in this claim, occurred after the initial surgery on January 27th, when he saw the specialist for the laser eye treatment. So yes and no, if that explains anything.
Yeah, that helps. Thank you.
Okay, any other discussion? Okay, we have a motion and a second to deny claim number 7363. All those in favor say aye. Opposed? Two opposed? Two opposed? I'll vote to deny the claim. So claim number 7363 is denied. Okay, we're moving on to claim number 7351. For personal injury, $30,000, and I assume we're making the call. Okay.
Good afternoon. My name is Mike Ditch, and I'm calling on behalf of the Kansas Legislature's Joint Committee on Special Claims Against the State. We're trying to reach Dennis Traub. Is he available?
Yes, sir. I'm here right now.
Hello, Mr. Traub. This is Susan Humphreys. I'm the chair of the Joint Committee on Special Claims in the State Legislature. The committee is hearing your claim number 7351 for $30,000 for personal injury. And you are on the speakerphone right now with the committee in the State House. The committee has been provided with all of your documentation. And I'm going to give you the chance to tell the committee in just a minute anything else that you would like us to know. And then when you're finished, I'm going to ask the attorney for the Department of Corrections to give us their response. And then when that's complete, the committee will take some time to consider your claim. And then our written decision will be provided to you within 21 days. Does all that make sense
All right,
to
ma'am.
you?
Thank. Yeah, yes, ma'am. It does.
Okay. All right. So go ahead and let us know anything about the claim that you'd like to tell us.
Well, it's just, I mean, that's not all the things that have happened, but those are things, and even staff agrees with me and stuff that knows everything that's happened, stuff that's never should have happened to me. I'm 65 years old now, and I'm still having problems with medical and stuff like that, as we all do. They're a contractor to the state and this and that and the other. We understand that. But it doesn't seem like at times they're willing to work at our best interests. Like the cancer issues that I had at Lansing should have never went to that point. I was told by the colorectal surgeon, the colonoscopist, when I finally got to see one after they did one of those 3-step culture tests and saw blood in my stool after I'd been telling them that all along. When he went to physically examine me, he found my liver was swollen, he found my bladder was swollen, all that. They hadn't even looked in my ears all those months that I was sick and all that kind of stuff the whole time, and all that could have been prevented from the beginning if they'd have done something when I reported blood in my stool and all that kind of junk. They would have been able to have done something to probably have caught that in stage 0 or 1. Instead of into stage 2, having to end up going through them telling me that I was in remission and all that. It's just, I really don't even know how to explain all of it. It's been mentally challenging I've had mental health counselors tell me that they don't even know how I've made through it, that I'm just very stubborn and an advocate for myself, and if I wasn't, I probably wouldn't have made it through all this. And I'm really at a loss as to how to even describe how all this happening has made me feel. It's caused a lot of different things that are going on with me now that are never going to leave me for the rest of my life. And I just, I mean, I've got all my documentation and paperwork from all these years and everything, medical form or sick calls that I've turned in, all that kind of stuff. And if I was to have sent all that to y'all, I'd have had a box and a half of legal paperwork to have mailed to you. It would have cost $100 and some to have even sent it to you. And you don't even have time for all that either. That's like that one paper states, Miss Stanley, my mental health counselor in Larned, and Captain Pritchett, who was my high-risk unit team, they're all will verify that all this has happened. There's even some officers that are working here now there for Larned that saw all that happen in Larned. My blood pressure issues being crazy and all that kind of stuff. They tried to say that I had refused blood pressure meds and stuff like that, and that wasn't true because I had 2 officers with me as witnesses that I never did refuse anything. I was the one that instigated the fact that my blood pressure was off the chain, as we call it, out of control, doing this and that and the other. It was getting up to stroke levels and all that kind of junk. And when my pulse is in the 30s for 4 days in a row, or 3 days in a row, and they turn around and tell me that I'm fine, I can go back to my house and all that kind of, I just really don't know how to describe anything more than what I put on the paper to try and explain what's happened.
Okay, thank you. Thank you, Mr. Traub. We're going to hear now from the Department of Corrections, their attorney, and what their response. So go ahead, Mr. Bushbaum.
Thank you, Madam Chair. Mr. Traub claims several injuries and incidents at 5 KDOC facilities since 2016 that have caused him continued mental and physical anguish. There are dozens of claims within his legislative claim alleging various types of what he argues is medical malpractice against Centurion staff. I reviewed his medical record extensively. It took a long time. Everything was very thoroughly detailed. He's not being facetious. There were quite a few documents to go through. And he really alleges 2 things. One, that he sustained injuries to his face during an incident in his cell in 2016, in which he fell against a locker in his cell while he was by himself and lacerated his face. And then second to that is claims of issues with his cancer treatments over the years. He also alleges several issues with Horizon Healthcare, a prior medical contractor for the department, regarding the same cancer diagnosis and treatment that he was just alleging in his testimony. Centurion staff always had follow-ups with him. He was never denied an opportunity to see a doctor. He was followed up weekly at least with a lot of his issues. He was given proper chemotherapy while he was in custody, and he should have filed at any of these facilities that he alleges a single property, or my apologies, personal injury claim. He did not do so, not a single one for any of these facilities regarding the issues that he has in here, not even one that is similarly related to any of the issues. And so with that, the department is unable to pay his claim under 44-16-104A, which requires residents to submit claims for personal injury to the facility within 10 days of the alleged personal injury. Thank you.
Thank you. Committee, do you have any questions for Mr. Bushbaum or for Mr. Traub? Representative Mon.
Mr. Traub, how did you come up with the $30,000 valuation of your injury? Did you hear me, Mr. Traub?
To take it, yes, sir.
How did you come up
Hello?
with the? Yeah, I just had a question of how you came up with the $30,000 evaluation? Or...
Yeah, like I said, I've been told that the boxes of paperwork that I have to prove all this and everything are multiple, and that it would be worth a lot more than that. I'm getting ready to get out here in about 5 months probably, and about 4 to 6 months actually. And when I walk out the door, I don't have anything. And instead of having to go to an attorney and having to go through all that paperwork and doing all this and that and the other, even though it could possibly be worth even a lot more money than that, I don't have anything when I walk out the door. And that right there would be suitable for me to at least get out and get myself a residence and possibly be able to do something with my life to make it after being in here for all these years. And I know that's my own fault that I was here. I regret the hell out of that, believe that. I wish I'd have grown up a long time ago instead of about 10 years ago. But that would give me an opportunity for, because things are so expensive on the streets now, when I walk out the doors with $100 gate money, I've got nothing. And that at least would give me an opportunity to set me up with a starting point for when I walk out the door from here. I can't get a minimum wage job anywhere in the DOC because of the issues that I have medically and everything else. They won't allow it and all that kind of stuff. And I have no other way to try and put something together for when I walk out the door instead of trying to do something like this after I walk out the door. And if I might say, the gentleman said I was in a cell by myself. I was in a 4-man cell, and there are cameras pointed into every one of those cells when they overdosed me and had that accident. And I'm sorry about all this paperwork trail, but I'm not an attorney and I'm not experienced in all this, so I don't know how to do all this stuff. I'm just an old man and a layman, and all these rules about doing this and that and the other are beyond me.
Okay, thank you. I appreciate that. So
yes, sir.
Do I take it that you did not file any personal injury lawsuits or anything else?
No, sir. I have not filed any lawsuits. I was told that these are ongoing issues with my vertical and equilibrium, the sight in my left eye, the cancer issues and all that kind of stuff. I ended up having to go through 2 sessions of chemo, one with chemo pills and one with 3 different kinds of chemo, and they ran out of my chemo pills twice. I never did get to finish it completely, or I didn't never get to finish the IV chemo completely because they ran out of it when they changed from Centurion, Corizon to Centurion. And all. It's just been a total mess, and I haven't known what to do with any of it.
Okay.
I'm just a lay person. I mean, I don't know anything about all this stuff.
Oh, thank you, Mr. Traub. We appreciate it. We understand. If you, just 1 second, hang on just 1 second.
Yes, ma'am.
So, Mr. Traub, I just want to mention that this committee is the really committee of last resort. And so those are the cases that we hear the monetary amounts. And if there's still an opportunity for someone to file a lawsuit and that hasn't been done yet, that kind of has to happen before we do the special claims against the state. And so we will take all of that into consideration from when we discuss it as a committee. But I just wanted you to know that that's where we stand, and that's where the statutes have us. You know, that's where our lane is that we work in. And so we're the last resort that people come to when they have a claim against the state. And we need to make sure that they've exhausted all their other remedies. So,
okay, yeah, that's why I was trying to do this, was instead of going through all the lawsuit steps and all that kind of junk and this and that and the other, just to settle it and get it done.
Sure. Understand. Okay. Thank you. We will, again, take some time, discuss your case, and let you know what we decide within 21 days.
All right. Thank you, ma'am.
Okay. Thank you. Bye-bye. Okay, committee, do you have a recommendation on this one?
Madam Chair,
Representative Mon.
I will move that we deny it without prejudice because he hasn't gone through all his remedies, hasn't exhausted all my remedies.
Is there a second? Second by Senator Dietrich. Committee, do you have any other comments or questions, discussion on this? I am curious, Merle, when we do provide them with our written decision, do we explain what without prejudice is, or do we give them any sort of explanation on why or how we came to a conclusion?
Madam Chair, generally the letter just communicates whether the item was denied or dismissed, what the resolution is. The committee actually has a rule that there is no need to give an explanation to the claimant, so we usually don't communicate whether they have options to pursue. That's up to the claimant typically to determine.
All right, thank you, thank you. Okay, any other discussion then? Okay, there's a motion on the table to deny without prejudice claim number 7351. All those in favor say aye. Opposed? Okay, so that will be denied without prejudice. Claim number 7367 is another claim where the claimant accepted a settlement, and he signed, Jonathan McCune signed that on December 11th. He accepted a settlement of $172. And so we need to dismiss, or we need to talk about what we want to do. We still have an action we need to take on that claim. Senator Dietrich.
Yes, thank you, Madam Chair. Similar to the one we did earlier in the meeting, I will dismiss this claim because it's been settled. Claim number 7367.
Do we have a second? Second by Representative Mon. Any discussion on that? Okay, then claim number 7367 will be dismissed because it's been settled. Oh, sorry, I didn't vote. I forgot, sorry. All those in favor of dismissing that claim, say aye. Aye. Thank you. Opposed? Okay, that claim is dismissed. Okay, our next three claims are all Willie Simmons, and we will see if we can get him on the phone. I know I interchanged. Oh, the one right before. Okay. Thank you for the clarification. Okay. Are we gonna dialing now? Okay.
We will now connect you.
Hello.
Good afternoon, ma'am. My name is Merle, and I'm with the Joint Committee on Special Claims Against the State. We're trying to reach Mr. Willie Simmons. Is he near you, ma'am?
Yes, he's right here.
Mr. Simmons, are you there?
Are you there?
Yes.
Okay, thank you, Mr. Simmons. Good afternoon. This is Representative Humphreys, and I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is first hearing your claim number 7314. We've carried it over from previous meetings. And right now you are on the speakerphone with the committee. That claim is for property damage for $29.80. And we would like to hear anything else that you would like to tell us about the claim. We have all of the documentation that you filled out. After you speak, we will hear from the Department of Corrections, and then we'll ask questions, and then we will take some time to consider your claim and let you know. So tell us what else you would like to in support of your claim.
I'm sorry. Mr. Simmons has hearing aids, and it's really hard for him to hear. He can't hear anything right now.
Okay. What do you suggest?
I know he's about to have ear surgery in about a month, and he was wondering if he could postpone it one more time until he'll have surgery soon.
Ma'am, if you could please just stand by. Madam Chair, we did provide in writing to the claimant that this would be his final opportunity to be heard on the claim. At any point, he has the option to write to the committee to communicate that he'd like to reschedule this. So the committee did make the motion at the last hearing. This would be his final opportunity.
Okay, thank you. So committee, do we have any thoughts on that?
That is correct. Ma'am, we can let the claimant go, and we can read a summary of the claim and hear from the agency, or the claimant could even just stand by, but we can read a summary of the claim and hear from the agency, and the committee can consider those.
I think that sounds like the best thing because, we did let him know this would be his last opportunity because we have carried it over twice. This will be, the third time he's been on the agenda. So we can go ahead and look at the documentation and hear from the agency, and then we can discuss those three claims. Does the committee agree just informally about that? Okay. All right. Okay. I think we'll, so ma'am, did you hear what we said about that?
Yes, I did.
Okay, I think we'll proceed that way. You are welcome to stay on if you would like to. You don't need to necessarily, but if you would like to stay on, and then you can let him know the information, that would be fine. Whatever you choose on that will be fine with us.
Okay, sounds good.
Okay, so we're going to go ahead and hear claim number 7314. Merle, if you could give us a summary of that claim, please.
Yep, this is claim 7314, Willie Simmons versus El Dorado Correctional Facility for property damage in the amount of $29.80. Claimant states his padlock and external radio antenna connector were damaged when his property was held by staff following an altercation with another inmate.
Okay, thank you. Now we'll hear from the department, from Mr. Bushbaum.
Thank you, Madam Chair. So the facility agreed to pay $5.29 for the padlock. However, Mr. Simmons never included the antenna jack in his original facility claim, and they were unaware of that claim until it made it here. So the facility has settled at least the lock portion of it. However, he has refused to sign his W-9, which, as we know, is required in order for the facility to make payment to their accounts for awards. And that's really where this comes from. The issue that we have is that he never included it in any facility claim. It's not in any property claim. It wasn't alleged missing until it got to this level. And KAR 44-16105 says property claims shall be paid shall not be paid unless loss or damage directly resulted from staff negligence. He hasn't alleged staff negligence either. And since the claim does not establish that, the department recommends that the claim be denied.
Okay, committee, do you have any questions? I do have just a quick question. So the department offered the $5 and something for the padlock, but and then but didn't know about the other antenna and so on. Is that correct?
Correct, Madam Chair.
Okay. And he denied it, or he just hasn't done anything because he hasn't signed his W-9?
He accepted the payment for the
Okay,
padlock, but
okay.
yeah, of course, he has not signed it yet. So he has been unable to receive his funds.
Okay, thank you. Committee, do you have any other questions? Representative Mon.
So does the agency deny that the antenna was damaged? I mean, do we have any information about that?
The facility denied that there was an antenna jack in the locker, because what had happened is there was a locker and there was a padlock on that locker and there was property within that locker. He claims that none of the rest of the property that was within the locker was lost. However, they had to cut the lock in order to have entry into the locker. So we paid for that padlock. Clearly, staff had to do that. However, an antenna jack was never brought up to the facility for review in the first place.
Okay, any other questions, committee? Okay, thank you. We will conclude with that claim, and we'll move on to claim number 7315, property damage for $300.
Claim 7315, Simmons versus El Dorado for property damage in the amount of $300. Claimant states he ordered 50 typewriter ribbons through the agency's canteen service, which were found to be defective.
Okay, now we'll hear from Mr. Bushman with the agency. Go ahead.
Thank you, Madam Chair. So he requests $300. Over the span of 4 years, he purchased 50 typewriter ribbons. That was confirmed. I confirmed those purchases. And he only made a claim recently, and he continued to buy them for 4 years without notifying staff that there was an issue, without notifying the canteen that there was an issue with any of the products. And KAR 44-16-102 states that each inmate shall report every loss of or damage of the resident's own property immediately, and that the warden shall be required to accept any property loss or damage claim unless it's made within 15 working days. He certainly did not do that. His first receipt goes back to December 31st, 2019, and he's alleging that typewriter ribbon is also defective, but he did not make a claim until this year. Of course, he has also not alleged staff negligence. KAR 44-16-105 and 118, or IMPP 01-118, say that risk or claims shall not be paid unless loss or damage directly resulted from staff negligence. As there's no proof that there was any staff negligence that prompted the ribbon to be damaged, the claim was denied. Thank you.
Thank you, Mr. Bushman. Does anyone have any questions? Yes, Representative Mon.
Thank you, Madam Chair. Yeah, it's even in judiciary, we sit next to each other, which makes it even.
You're not going to next year, just.
Oh, okay. Oh, yes, we have a vice chair. Sorry, anyways, I wanted to clarify, has it been confirmed whether or not the ribbon is in fact defective?
It has not. However, within 1 week of a receipt of a defective canteen item, they're supposed to report it through a Form 9 property loss or property damage claim. Very standard, just like all of the other claims for us for property today. And for he just simply didn't report it until now, which kind of renders those 30 purchases, unfortunately, or 50, unable to be paid out.
Okay, thank you.
Any other questions, committee? Okay, we'll move on to claim number 7330, property loss in the amount of $59.13.
Claim 7330, Simmons versus El Dorado Correctional Facility in the amount for property loss in the amount of $59.13. Claimant states his property was misplaced by medical staff when he was treated for a physical assault. Property includes toiletries, socks, wave cap, and boxer briefs.
Okay, thank you. And now we'll hear from Mr. Bushbaum.
Thank you, Madam Chair. He submitted a facility claim on March 27, 2023 that was denied because he submitted it after 15 days that are required to allege property loss. And however, the items I did manage to track down, they were stated in the first paragraph under the facility claim. All of them were accounted for. Mr. Simmons went in because of a disciplinary action to restrictive housing and then the infirmary, and was released back to general population on January 30th, 2023. He signed an inventory sheet during all of this. So all of his items that are listed in this are stated on that attached inventory sheet, including the Colgate, the toothpaste, the Noxzema cream, toothbrush, everything aside from the wave cap that he alleges in his legislative claim. However, I was able to find that on January 25th, 2023, he was not in compliance with the amount of property he had, and so he had to release several items to family members, and he did so. He sent 3 excess wave caps to family, and all items being claimed by Mr. Simmons were listed on the property inventory sheets, or property removal form in this case, and his signature on each indicates that he was in possession of these items at the time of the alleged loss. And Mr. Simmons also states in his response to question 3 of the legislative claim, quote, intentional infliction of emotional distress, $500, and the value of the items missing or stolen, $59.13, end quote. It is unclear if he is intending to incorporate that into his claim. However, KR 4416-104 and IMPP 01118 state that residents, of course, have 10 calendar days to report personal injury claims. Mr. Simmons did not file any personal injury claim at the facility level. And since he has failed to exhaust his administrative remedies as required under Rule 2, the department recommends that whatever personal injury claim he may be attempting to make be denied.
Thank you. Committee, do you have any questions on claim number 7330? So the items are still missing, or you have them? That's
Madam Chair, he alleges that they're still missing. However, they're on all of his inventory sheets, including the one that is attached here that signs that says he has all of them, that he received them upon his return from restrictive housing and the infirmary.
We've not like really looked to see. Yeah, I mean, I know the inventory list. I have a bit of a concern about the inventory list because it's hard when you're looking at a box of stuff to know if everything's there. And we've talked about that before many times. And so just because he signed it, I just wondered if you happen to confirm that he actually had the items besides the inventory list.
Of course, he signed the inventory sheets prior to making the claim, the facility claim. Mm-hmm. So he's alleging that the claims are still or the items are still lost.
Okay. Okay, any other questions anyone has? Okay, does anyone have a question? Well, Merle, are they still on the phone?
Ma'am, are you still there with Mr. Simmons?
They've hung up. Okay, all right, they probably couldn't hear. Okay. Okay, all right, then no other questions about 7330. Okay, then we'll close the hearing on that one, and we will go ahead and talk about all 3 of these claims. The first one, what was the first one about? The padlock. Mm-hmm. Representative Mon.
Madam Chair, I would just on claim number 7314, I would move that we reimburse the claimant for $6 for padlock, and
Did he accept? He just hadn't signed the W-9.
Correct, Madam Chair. He has already been offered reimbursement for it. He has refused to sign the form that allows him to actually have the award credited to his account.
Do you know why? Is it sort of the same reason with the garnishment issue or something else?
No, Madam Chair. My understanding is that he is unwilling to sign it or give his correct social security number on the form because he is waiting out for the antenna jack from this claim.
So if we don't need to do anything here because the authorization for the padlock has already been authorized, right?
Correct, Representative. The initial, sorry.
Yeah, I'm sorry, and I didn't mean to talk over you, but I guess if we're not going to award the rest of the 2980, other than the padlock, we don't need to do anything.
Yes, Representative. The padlock is actually included in the total for the $29. So, but yes, that is correct.
I'll withdraw my motion. I'll move that we just deny the claim.
Representative you have a comment?
Thank you. Just a quick follow-up question. So since Mr. Simmons never filed a claim for the antenna with the facility, if we denied the claim today, would he still be able to file that claim with the facility and potentially get reimbursement if it's found to be a valid complaint?
He had to have filed it within 15 working days, and he is well past that. Why he didn't include it in his original claim, I don't know the answer to that. And he didn't file it up in the 15 days that he had after learning that it was missing.
Okay, thank you. Any other discussion on claim number 7314? Okay, all those in favor of denying the claim for $29.80, say aye. Opposed? Okay, that claim is denied. Claim number 7315. This is the typewriter ribbons, which he's using in his some of his documents. I mean, I don't know if it's not, I mean, I don't know if they're defective or not, but these look like they're doing fine. So do we have any discussion on that one? Senator Dietrich.
Thank you, Madam Chair. I'll go ahead and make a motion just so we can get the ball rolling. I think because it was over 4 years, 50 typewriter ribbons, we have no evidence of them being damaged. I think I will move that we deny this claim 7315 for the amount of $300.
Second by Representative Mon. Any discussion on that one? Okay, all those in favor of denying claim number 7315, property damage in the amount of $300, say aye. Opposed? Okay, that claim is denied. And then the last one, claim number 7330, property loss in the amount of $59.13. We have do we have any discussion? Do we have a motion on that one?
Madam Chair, I move we deny claim 7330.
Do we have a second? Second by Representative Mon. Any discussion on that one? Okay, no discussion. Then all in favor of denying claim number 7330 for property loss, say aye. Opposed? Okay, that claim is denied also. Okay, committee, we have done good work today. Yes?
Madam Chair, we have one.
We have
one outstanding claim with Mr. Mullet.
Yes.
And that is claim 7360, and I can dial him now.
Okay, let's see. That was on your agenda for 11:25 this morning. What is a? I don't know. waves.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and please dial the extension number. Press the star key to start over. The selection is invalid. Please re-enter. Sorry you're having trouble. Please try again later. Goodbye.
Merciless.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen to the prompt. Please dial the extension number. Press the star key to start over. We will now connect you.
A3 Hunt.
Good afternoon, sir. This is Merle with the Joint Committee on Special Claims Against the State. We're trying to reach a Joseph Mullet. Is he available by chance?
He is. I have him in my office right now.
All right, thank you, sir.
All right. I'm going to put you on speakerphone unless you'd rather me just hand the receiver over. Does it matter? Or...
Whatever's easier for you is fine.
Okay. Let me put it on speaker, and then if we have trouble hearing, then I'll just pick it up and give him the receiver.
Okay, that sounds great. Good afternoon, Mr. Mullet. This is Representative Humphreys, and I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing your claim number 7360, personal injury in the amount of $75,000. You're on the speaker phone right now with the committee in the State House. The committee has been provided all of your documentation, and I'm going to give you the chance to visit with us about any additional information you'd like us to know. When you're finished, I'm going to ask the attorney for the Department of Corrections to give us their response. And then when that is completed, we may ask a few questions, and then we will take time to consider your claim, and our written decision will be provided to you within 21 days. Does that make sense to you?
Yes, ma'am.
Okay.
Now, I'm kind of new to this.
That's okay. No problem. We're happy that we're able to visit with you, and we want to hear what you have to say. We have your claim in front of us, so why don't you give us, if there's any additional information that you'd like us to know, please tell us now.
Because what happened is, I got in an altercation with another inmate, and I got sprayed. I was actually cuffed up, which I complied, and then they would take me to the clinic because my eyes were burning bad, right? I put my eyes are burning. Next thing you know, I get picked up and I just get head first straight to the ground, and I got hiccups behind me, and my nose split open like it wasn't nothing. They faced out with me. It was bad. I wasn't being disrespectful, nothing. Because when I took to the clinic, the woman asked, she thought I had a concussion because I was so nice. I had no idea why they even did that. I'm going to hold them accountable for it. Just like I expect why they hold me accountable for it.
Okay, thank you. And so if I'm reading correctly, that happened in October of this year?
Yes.
Okay.
Yes, ma'am.
Okay. All right. We are now going to hear the response from the Department of Corrections.
Thank you, Madam Chair. Mr. Mullet has attached a personal injury claim that he submitted on October 11th, 2023. You'll note it's also part of KDOC's Attachment A. He filled it out, and then he mailed it directly to the Secretary's designee instead of working it through the facility process. It was sent back to him with a letter accompanying it, also attached. explaining to him that it needs to go through the facility rather than go directly to the department. He never refiled that personal injury claim at the facility level. In addition to that, a review of his medical records, I looked at this stuff extensively. He did receive a CT scan at Susan B. Allen Memorial Hospital immediately after the attack that he claims, and that was on October 11th. The scan was done of his neck and face. The attending physician noted non-displaced fractures were observed around his nose. He states these fractures will heal medically without medical intervention, and medical staff informed Mr. Mollett that treatment was unnecessary. So his claims and his legislative claim that he needs facial reconstructive surgery is incorrect. He is cleared, essentially. He is still being seen by Centurion medical staff consistently, and he has since the incident with pain medication as needed. He has also filed a civil rights complaint with the department as a named party, and that complaint is active. The complaint alleges the same facts and issues stated in his facility and legislative claims. He has also submitted a settlement to the Joint Committee as a supplemental document in which the department would pay $25,000 in exchange for terminating his lawsuit. The department declines to accept that settlement. And since he has active litigation, the department recommends the claim be dismissed without prejudice for Rule 2. Thank you.
Okay, thank you. Committee, do you have any questions? Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Bushville. If there was a settlement offer for 25, and it was why did the threshold for his 75,000? What is he? And I probably should address it to him as well. What is it predicated on? The amount of damages that he has listed at all, since you've testified that everything is put in place for him to be made whole already.
Yeah, since he does not require surgery of any kind, and he requires no further treatment medically, I do not know what that number is predicated on, either one of them.
Okay, thank you.
Okay, any other questions for the department? Okay, then questions that you'd like to ask Mr. Mollett? Anybody? Senator Haley.
Thank you, Madam Chair. Mr. Mollett, can you hear me? Hello?
Yes.
Okay.
I'm gonna pick up the.
Okay, well, I'm trying to understand that you have another open case. Wondering how you reached the requested amount for this claim of $75,000. What is that based on, please, sir?
Where'd I get it?
Yes. Where did that number or that amount come from of $75,000?
We were looking it up and stuff off of other stuff we were going off of. You know, I figured it in place because when I seen the nurse, cause it's like I got part of my nose drooping down. You know, they told me I'm going to need reconstructive surgery on some of it, and plus that there's tentacles or whatever that's inside my nose that they couldn't mess with right yet. So they told me I had to come back. So between that and medical and everything, all in once, put together.
So, sir, so if all of the medical needs that you have were to be found eligible for some other compensation, in other words, if they were covered, then you wouldn't need 75,000. If it were determined that your nose or your face would be made whole, there wouldn't be need of what you're asking. You have the $75,000 for anticipated medical costs? Yeah. Sir?
I'm listening. Yes, sir.
You put $75,000 for anticipated medical costs. Is that what you're saying?
Yes, sir.
You think that you will need $75,000 in medical costs, and that's why your claim is what it is.
No, not just the medical cost, no, sir.
So, okay, well, I'm just trying to understand why you came up or how you came up with this number for $75,000, and I appreciate it. Thank you. Thank you, Madam Chair.
So, Mr. Bushbaum, you have a response?
Yes, thank you, Madam Chair. It goes without saying, the resident is not incurring any charges for his medical care while in custody. So if he's requiring necessary medical surgeries, they're going to be covered. He's not incurring separate charges. And both the physician at the hospital he went to, Susan B. Allen Memorial Hospital, that did the CT scan, said his face is fine, he has some fractures, but they'll heal without treatment. And that was followed up by Centurion medical staff that agreed with that assessment. So I'm not sure where he's deriving the necessary step to get surgery, but it is not medically necessary.
Okay, thank you. Committee, do you have any other questions? So I do have a question, Mr. Mullet. You mentioned in your claim that you use the phrase excessive use of force. And I'm curious if you intend to file any sort of suit or anything because of that, or if this is part of it, or what your intentions are.
Well, it depends how this goes. I'm planning on filing suit against the two officers because, because just like I get a hold accountable for everything I do, in which I think they shot, and if I'm wrong, I admit to it, and I tell them, I don't sugarcoat it. Yeah, I did it, or and I figured the officers ought to be let them, especially when I was there. All they kept doing is talking to me and talking back to me, thinking it's funny while I was there. The two officers, Officer Sin, Officer Burnell.
Okay, so yeah, thank you. And the committee may have another question for you, but right now, Mr. Blueboss has a comment. Go ahead.
Thank you, Madam Chair. As I know, it's been a long day. As I've stated, and also in the department's response in the second paragraph of the first page, he has filed a civil rights complaint in which the department is a named party for these alleged facts and seeking the same compensation that he is in this legislative claim. So it's all kind of wrapped up into that.
Okay, thank you. So there is some sort of civil claim pending right now.
Yes, Madam Chair.
Okay. Okay, thank you. Committee, do you have any other questions? So, Mr. Mullet, we'll take all of this into consideration. The fact that you do have a lawsuit pending would mean for us that, this committee is set up as a last resort. And so when you have something pending, it kind of precludes us from being able to issue acceptance of the claim because, again, it's last resort. So we will take all of that into consideration. We hear you, and you did a fine job, even though you were a little bit nervous. And we will let you know within 21 days what our decision is. Does that make sense?
Yes, ma'am.
Okay, thank you.
Yes, ma'am.
Okay.
Thank you for your time.
Sure. Of course. Bye-bye. Okay. So, committee, do we have a motion on that one? Carl. Oh, sorry. Representative Mon.
We dismiss for, I guess, Rule 2.
Okay. It's without, yep. We have a second. Second by Representative Vaughn. Any discussion on that one?
I guess I should be clear without prejudice, right?
Yep. Okay. All right. No other discussion? Okay, so then the motion is on the table to dismiss without prejudice according to Rule 2, claim number 7360. All those in favor say aye. Opposed? Okay, that one is taken care of then. All right. Committee, we, as far as I know, we're done with our work for the day. I do think Merle is willing to tally up our recommendations.
Yes, ma'am. So today the committee recommended payment all from existing resources on 2 claims. One for $118.12, the other for $2,000. So for a total of the day was $2,118.12. For the interim, the committee has recommended a total for standard claims, so excluding motor fuel refunds, a total of $3,759.86 for 9 claims.
For our 3 meetings.
That is the total for the standard claims. That excludes the motor fuel tax. So if we then add the motor fuel tax, the overall grand total is $49,342.82. When I look back on last year, or for the 2023 interim, the committee ultimately recommended a total of $15,895 for 18 standard claims. And if we add the motor fuel tax, the motor fuel refunds, that's a grand total from last year of $22,982. So less motor fuel tax, more standard claims last year.
This has to be one of the lowest standard claims, I would think.
And we have no carryover, and I've been on this committee for 4 years, and this is the first time I don't think we've ever had one. We've had no carryover from one interim until the next interim.
Yep. Okay, committee, do you have any questions or anything for the good of the committee that you'd like to say? Yes, Senator Haley.
Thank you, Madam Chair, and I appreciate so much the way in which you have handled it and Vice Chair handled it prior to. And I always make my plea as the longer standing member of this, that we suggest and very strongly, especially since we have new counsel with Department of Corrections. If we could, please, Madam Chair, if you might consider, as I know Senator Dietrich is known as well, that we suggest the Department of Corrections streamline the inventory so that, as you and I have shared when you used to sit here on my left, it would just make, I think, this docket so much easier to manage if the department had in place, Mr. Bushwell, the inventory, what can be had, what can't be had, what's missing, what isn't, whether it's sweatsuits or sweatpants or, radios and I would just, for the good of the cause, for efficiency in government and for implementation of it, I would just ask you to consider to make that a part of the report, that the department help get itself in better shape, Department of Corrections, that we might all implement this better. Thank you.
Did you have any specific recommendations?
Madam Chair, I was so taken by those that were in part compiled by Senator Dietrich last, and I don't know what happened if those were sent over, but or where that is. Really, I don't know what happened to it, but I know that she was diligent. She's one of the more thorough members of the Kansas Senate, as you know. And so I don't know what happened after that, but I would like to renew her insight and effort, if that would be a possibility at some point.
I wonder if we might be able to request that the department comment on Senator Dietrich's suggestions now or in writing later or whatever. Would you introduce yourself too, please?
Vicki Brungart with Department of Corrections. Senator Dietrich, I never saw the recommendations. This must have been prior with Randy Bowman. Is that correct?
It was with Randy.
Okay.
And I must say, I do believe several recommendations were made, but they're in the process of being made. So
I do know, I can explain that we are changing over our system from our AS400 to a Microsoft system, where we will have a more electronic version of inventories. And it'll be something that the officers will have on a tablet when they go into the room, and they can check whether things are there or not there, and it'll keep a regular tally more like. and easier to read as well, because some of these are hard to read when they're the handwriting. But that is still in the process. It hasn't gone live yet. So that is one update I can give you. So I know they're working to improve it better.
Good, thank you, we appreciate that. Yes, Merle. Mm-hmm.
I would just comment, if this is a measure, the amount of claims received by this committee is down noticeably from the previous 2 years. And I was aware that Senator Dietrich sent the letter. And right now we've had a total of about 65 claims that we've accepted throughout the year. And that's usually closer to 80. So I can't define whether there's a strict correlation there, but there's less claims this year.
Way to go, Brenda, thank you. Yeah, okay, good, thank you. Did you have something else? Yep.
I do think Revisor Heim was going to reference the claims bill. He's drafting it now, and I believe that will be introduced in the House committee this year, whereas it was introduced in the Senate committee last year. So that typically means that the House member on this committee may field some questions, and that committee would be House Appropriations.
Okay, that makes sense. Yeah. And I'd say most of these are pretty, I know we've had some years where it was not easy to carry that bill for certain reasons. So this one should be pretty easy, Representative. Okay. All right, great. Anything else for the good of the committee? I especially want to thank the staff. Thank you for your diligent work, and we really appreciate you all being here with us. And I just, again, want to emphasize that I think it's pretty incredible that we spend a whole day listening to folks as a last resort. And I just respect our state and our legislature and whoever put that in place. And I'm appreciative of the fact that some of the most vulnerable folks in our state get to talk to legislators on the phone, and they get to be heard. So I think that's important. And Merry Christmas to everyone, and have a Happy New Year, and we'll see you in January. We're adjourned.